Hey, it's your girl, Break Bread with Duchess 1.0 at Duchess Break on YouTube. If you are interested in TV reviews, fun, light commentary, slide on over to my channel, Break Bread with Duchess 2.0. I am also running a promotion over there. It's my first baby. This is my second baby. Welcome to the chat. Welcome to the YSL People Trial. We do things a little bit differently over here. I'm starting to get started a little bit later so I can get past all the breaks and do a little recap before we actually go live. So I have about 5 minutes before the audience is scheduled to join me, and I wanted to use this time to catch you guys up a little bit. So, what has been happening in this case? We are on day 114. Little Woody has given his testimony because I'm sure by now you know that the first judge was recused, and I am doing this with the music. Let me turn the music off. Is that better? I'm so sorry. This is why I come in early so that I am not screwing up my lives. But anyway, so just a quick recap, just to kind of bring us forward to where we are. Little Woody did do his testimony last week. We heard from him. We will hear from him some more on next week. And you know about the ex parte and all of that. So part of the resolution was to redo his entire testimony. He did finger Young Thug in the murder of Nut as like the orchestrator and them, and that he talked about that in his uh, police interview recordings. So that came out because they introduced that into evidence, because Lil Woody has maintained that he doesn't recall anything that he said to the police. He was just trying to get them off of him. And whatever he had to say to spin them in a direction, he would do that. So from my perspective and watching these interviews, we have times where he was locked up. We have times where he is in jail uniform and chained to a chair. We have times where he's just in regular clothing, but there is always a threat of his history. Him being He wasn't necessarily caught with a pow pow, but he was pow powed at, and so he defended himself. Therefore, he was in a convicted felon in possession of a firearm. Or maybe he wasn't a convicted felon in possession of a firearm, but he definitely is on probation. And so there always was kind of the carrot over there. And you see this kind of song and dance where Woody goes from playing the victim and being in distress and needing some help and don't want to go back to the sales of it all. Okay, 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 okay. You got me. You got me. I'm gonna help y'all. I'm gonna help y'all. I'm gonna give you some information. Like it's a cycle that happens so many times in these interviews. I start to see it as a script, and it also becomes kind of comical. Like you can almost time it, the antics. The detective, one of the detectives says that he likes to dance. Like they know that he likes to dance. Um, there is a portion of it where you kind of wonder, is he the one that did this? You don't really know. And is this why he's doing this song and dance? So the question became, who are you going to believe? Are you going to believe 2015 Woody in these interviews, or are you going to believe 2024 Woody on the stand, where he doesn't recall anything and that's not really what happened? He's supposedly telling the absolute truth on the stand, and he lied about everything else. But the circumstances are pretty much the same, if not worse, for him. Um, Especially with all the witness coercion and all of that going on, allegations, I should say. Additionally, another big thing was Brian still brought up his treatment and wanting to question him on his mental state when he gave these police interviews, and when he's giving his testimony, because he was held over the weekend and not given any food, stripped of his clothing. Like, that weekend of contempt was really a message, like, you don't want to um spend the rest of the time here while we're on trial, and it could be years, because incorrectly advised, they can keep him until they finish not just this trial, but everyone that they have lined up. And it's supposed to be like over 20 something defendants. The number is between 26 and 28. And so Brian still showed up in the room, and he was giving some hammer out some stuff, you know. And so we that was towards the end of the week last week. There are a few more motions that the attorneys had. And so this week the jury is out, and it's just non-jury court. And so what they do is they talk about evidence that they're admitting in. The state presents what they want to admit, and the defense gets to argue what portions, if any, should be admissible, and the judge makes a ruling. There are also motions that are being filed that get heard at this time. And so I kind of enjoy this time because I'm learning a lot, and I get to kind of see things play out. So, kind of get a background of things, and it helps when the trial is continuing forward and the jury's in the room, and different things are happening. So, I do like the way that this judge kind of has run this trial so far. um, I mean, for the most part, I think she's doing the best that she can, given the responsibilities that she has and who her boss is. Although if I'm honest, some of these arguments should make it really hard for her to keep supporting the state and this cause. And so there is a cautionary tale there, um, that I'm presenting. But for the most part, I have to respect the way she's running the courtroom, especially in respects to the way it was last run. So, without further ado, we are going to get into the watching of it all. So, I am going to mute my microphone. Boom. Here's what this well, Jeffrey Williams smiling. He's smiling, and appearing to be in good spirits. So, you guys, while we're waiting to get started, the biggest piece of this RICO so far is with the murder of Donovan Thomas. Jeffrey Williams is supposed to be the person who
State's
ordered it
case,
in furtherance
invite them to come back to court.
of the organization of the gang, otherwise known as YSL.
Yeah, thank you. not being here yet and the fact that apparently none of the defendants have been fed lunch yet, we're going to break, let them quickly be fed, wait for the state to get here, and then get started. So we'll be in recess before accomplishing a single thing.
Wow, guys. See, I knew not to start on time. I knew not to come in here at 12 o'clock. We are in, let's see. Court has been in session for about 30 minutes, maybe. And the state isn't there. You cannot make this stuff up. So they're at break because the defendants haven't had lunch yet, and the state isn't there. Like, not one single person was there from the state. So we're already starting off interesting. I'm gonna fast forward that, but um I'm gonna fast forward to get to that, but just to kind of bring it full circle. So there are several co-defendants that are kind of like co-conspirator statements. You'll hear that a lot. Co-defendants, that sort of a thing, which is kind of like grouping it all into the RICO. So Kenneth Copeland has firsthand knowledge, supposedly, of the ins and outs of the YSL gang, from the state's perspective, from everyone else's perspective, it's just a record label doing record label things that happens to keep company with some not so savvy characters. But Donovan Thomas was off in this situation, and Donovan Thomas is a known um, leader of the gang, the Bloods, I believe. And so the deal is supposed to be, although Jeffrey Williams, otherwise known as Young Thug, I am getting away from these stage names, but Jeffrey Williams, although did not pull the trigger, he ordered it as a hit. He also rented the car that was seen there, and Kenneth Copeland fingered him as the person. Kenneth Copeland was there with him when he rented that car, and Kenneth Copeland also um, has driven that particular car. But Kenneth Copeland says he passed the car off to his friend Threat, and he don't know what happened after that. Threat is no longer with us, so we will never find that out. And there is an argument in place that this rental car was to travel to Miami, because shortly after Donovan Thomas was off, they also kind of trickled into Miami. And it wasn't just to get away or anything like that. He actually had a show there that weekend. So, what is true? All right. So, we're going to fast forward. I'm going to mute. We're going to fast forward, and we're going to get back to court.
The first things we need to tackle are whatever the evidence is going to be with our next few witnesses following Mr. Copeland. So I know that co-conspirator statements, as well as all of the other evidence that y'all, the state, intend to introduce with the next several witnesses, has been provided now in detail. So I would propose that that's where we start, unless somebody thinks something else would be more efficient. That work for everybody? Okay, so have y'all been able to get together on any of it? come to agreement on anything, or are we gonna litigate all of it?
Your Honor,
Yeah.
just for clarity, are we discussing the evidence that was shared by Mr. Atkins on Friday night? Is that,
I mean, I think there have been a couple of different shares. There was, and I also don't off the top of my head know exactly when. There was one, and then there was the supplement, and then there's also, I think, something that Ms. Hilton shared that's in a spreadsheet, which I think covers the same things that Mr. Atkins provided already.
So, I think there's multiple, God bless you, there's multiple things. We
Yeah.
sent the evidence regarding upcoming witnesses a few weeks ago, according to
Right.
Mr. Atkins. What we sent on Friday, Your Honor, was the co-conspirator statements, making sure that the ones that the state intends to use were provided. And then yesterday, what I did was I provided a spreadsheet of the co-conspirator statements that are found within Mr. Garlington's wiretap, which had already been provided, and Mr. Sumlin's wiretap that had already been provided.
Okay.
So I just specified which statements from those wiretaps we intended to use.
Okay, so that's a subset of the bigger set.
Yes,
So,
Your Honor.
I mean, we can start there if y'all want to start there. Or are those going to come in later in the trial?
Those are going to come in later in the
Okay,
trial,
well
Your
then we'll
Honor.
set those aside for now.
Submitted the 31 through 60 witnesses.
Right.
Oh, I'm sorry. We submitted the 1 through 30 witnesses on August 8th,
Right.
2024.
Okay.
Judge, there was one matter with respect to the PowerPoint. I did send over the redacted one. And I spoke with, as I informed the court, I spoke with Mr. Williams about Mr. Ryan's statement and our intent to not use that.
Right.
So those two matters were off the table.
Okay, so yeah, we don't have to deal with a motion to suppress Mr. Ryan's statement because the state does not intend to use that. And I've also been informed that Mr. Kendricks is not going to be filing a motion to suppress the first hour and a half or 2 hours or whatever of his statement. So we don't have, that's also off of our to-do list.
Your Honor, on
Yes.
behalf of Mr. Ryan, in what was received on Friday, I think was our updated list of the people they actually intend on calling and co-conspirator statements, I believe. So we'll have Mr. Ryan's motions in limine, the basic ones of this is inadmissible hearsay, those types of items based on what we just received. I don't know if those are the immediate upcoming witnesses. We're going to prepare it as fast as we can. We're just kind of, as you know, getting the rolling. This is what's actually being introduced.
And so we, in my speaking with Mr. Williams, I did let her know that if she had specific objections, there may be things that we could agree to. She did name some and I agreed with her. So we were continuing to discuss those. So if after those conversations, Mr. Bassi and Mr. Williams feel like there's still more to litigate, that'll happen. But that conversation and that dialogue has started regarding those things that have been turned over to Mr. Ryan.
I think what probably would be the most productive is things that we have issues on, we make note of and make a record. This is the defense raises this issue, state agrees, so that they've been addressed and it doesn't, something got missed from the list or something like that. So we'll get with Ms. Love and do that.
That's fine.
We'll
that's
get
fine.
that to the court as soon as possible. I don't know if they're in the next few witnesses category or not.
I mean, I don't either right offhand, but if it is, we're litigating that stuff this week.
Right. Could the state provide a little bit of guidance?
No, Your Honor, the stuff for the Jamari Holmes are not within the next 10 weeks.
Okay.
Okay.
witness.
All right. That works. How about is Mr. Kendrick's statement that there's the Bruton issues on, right? And when's that going to get introduced?
So not in the next 4 weeks, actually, based on who it is that we intend to come before the witness that would
Okay,
introduce.
what witness will that be with?
Investigator Thor.
Well, y'all got him listed as witness number 5.
We do, but he has had, he will be moved down based on some circumstances that have occurred in his,
Okay.
he has some personal matters.
Okay, so is it still gonna be Burnett, Sledge, Zachary, Dean, Morton, Sprinkle, the phone custodians, Bernie, generally?
Generally, yes.
Okay, and then I guess Thorpe will be at the end of those now? Okay. And that PowerPoint, that's,
That's with Dennis.
well, that's with Dennis, okay. So he's, yeah, he's several out. Okay. All right, so great. That'll give y'all some time to get together on that statement to sort Bruton issues. Mr. Steele, you also seemed to kind of be making a broad argument that nothing in his statement, in Mr. Kendrick's statement, even if it doesn't directly implicate your client standing alone, needs to be redacted, or there needs to be a limiting instruction about that. Do you have any law to back that up?
I'm trying to get proper law, but in this case, there has been over objection, the announcement that YSL is a criminal street gang that Mr. Williams, according to 3 supposed experts, is a member of, in addition to Trontavious Stevens, said that Mr. Williams is a member of, in addition to Mr. Walter Murphy, had Mr. Williams allegedly as a member of. There may be others. And then in Mr. Kendrick's statement to law enforcement on October 6th, 2015, he discusses YSL, the crew, the gang. So I think that under Bruton, it's an element of the offense of criminal street gang as well as RICO, that I believe that that does not indirectly, but directly implicates Mr. Williams. But I'm looking for law on that, but that I do not want to waive that issue. In addition,
Well, yeah, just get me some law and we'll take it. Sounds like it's not quite as time sensitive as we thought it was, but we still need to get moving on it. So try to get me the law that would cover that. as
in
soon as you
addition,
can.
I'm sorry.
Go ahead.
No, I
Go
thought
ahead, I'm
we were
done.
Thought the sound record was done. Yes, I do want a limiting instruction, and that comes right out of the cases that I did cite, because that statement I cannot cross-examine. Mr. Adams cannot cross-examine Mr. Kendrick. That statement should be his alone. And it's confrontation clause, so it does not move the conspiracy forward. So it's not a recognized exception.
Okay.
So the second part of the question was, do you have law for the limiting instruction? And I already provided, but I could provide more.
Okay. And then I do want you to get with the state to try to come to an agreement as to what needs to get redacted to avoid Bruton, at least the classic Bruton issues, and we'll have to take up whether any kind of talk whatsoever about YSL gets included within that or not. But as to sort of the classic, Mr. Williams did this, which I doubt if he says something like that anyway, but something that would directly implicate your client standing alone, y'all, the state ought to know what that would be and be able to redact that out. And it's going to be played as a video statement, right? So, right or no?
We intended to ask questions.
Okay.
Versus.
That's fine. That's fine.
And Your Honor,
Yeah.
I did that in my motion. I was specific, and I give the timestamp where it starts. And I did it not only for Mr. Williams, but I did it for anybody else that I saw. And I did it for Shannon Stillwell. He's mentioned a great deal
Okay.
as well. So I believe that I flagged. If I missed anything, obviously, I'd like somebody to tell me, but I believe I've already done it. If the state agrees with it, then we need to figure out, make sure that the witness or witnesses know.
Sure.
But other than that, that's been done, Your Honor.
Okay, thank you.
And Your Honor,
Yes.
while we're on this topic, just an additional issue. Not only are there Bruton matters, but there's also just typical evidentiary rule matters such as speculation. At one point, Mr. Kendrick is asked who he thinks may have done this, for instance, and he names some names. That's the sort of thing that would need to come out, Bruton or not, if we're asking about speculation.
Okay, well, it sounds like it's not going to be played as sort of a running statement. It's going to be more targeted questions to the, I guess, investigator that conducted the interview.
Correct.
Okay,
So
so,
that would not even be an issue, putting in or trying to redact out
okay,
those kind of comments.
all right, good. All right, so let's turn to some of the specific then evidence that's going to be coming in with these next witnesses. So there's not anything controversial with regard to witness Burnett's evidence, right? And everybody else is silent, so I'm going to take that as a no for everybody else. All right, so Mr. Sledge, there are some co-conspirator statements from him. We already did his interview, right? Okay. Did we do his jail calls, or do we still need to do that? Maybe I can look at the more detailed exhibit list that y'all provided to everybody.
Your Honor,
Yeah.
before we discuss the jail phone calls, I do have one possible issue. I'm not sure how the state plans on doing this. I see what is this? The fifth row down on Mr. Burnett, comparison photo infinity Q5 or Q50 and gas station still photograph. I don't know exactly what that means or how the state anticipates that presentation to go in court. I don't know what Mr. Burnett's qualifications would be to compare two photos. So I'm just wondering how the state anticipates that playing out in court.
Okay. So are you looking at the first 30 witness list? Is that what you're looking at?
I believe I'm looking at the same thing as you. It starts with 81 and in Copeland under the witness.
No, I think you've got a more detailed one than I do. I need to find the more detailed one. That was a Dropbox link, right?
Correct, Your Honor. And in regards to what Mr. Shard is addressing, Mr. Burnett, both back in, I forget the exact date, but during Deputy Sprinkle's investigation, he worked at an Infiniti dealership. He's worked for Infiniti for over 20 years. So it's lay opinion testimony. Obviously, the state has to lay the proper foundation when he's on the stand, but
Right.
his ability to recognize Infiniti vehicles is through his 20 years, and he personally has driven Infiniti cars. So obviously that has to come out, but it's not scientific expertise. It's
He's
classic
an
lay
expert
opinion.
because he's got all kinds of daily experience with it from the last 20 years. Or
Yes, Your
whatever.
Honor.
Okay. So does that answer your question, Mr. Sharp?
It does. So I guess Mr. Atkins, you are going to ask him in front of the jury to compare the two photos and testify whether they're the same type of car. Is that
Correct, Mr. Sharp.
okay?
As one piece of his testimony, I mean, essentially, after the foundation is laid, he will use his lay opinion as a 20-year Infiniti rep to state his opinion of what specific vehicles are in both exhibits admitted and, demonstrative photos that are included in that Dropbox link.
I don't know if, I would like the court, Honorable Court, to look at the photographs. I don't know if we need a individual lay person to say that these are similar.
Do
There is-
I have, I mean, you, Mr. Atkins, are saying lay, but then you're describing something that I would think if this is beyond the ken of the average juror, it's expert, even if it's based on his 20 years as an Infinity rep. So which is it?
So, Your Honor, he can be, his experience as an Infinity rep, if he needs to be deemed an expert to state what the vehicle is in specific photographs, it's all through his training and experience of working with Infinity's hands-on for 20 years.
Okay, well, that would probably then be expert, but do you want to show me what it is that y'all are, I mean, I see that one of the things listed is comparison photo, Infinity Q50 and gas station still photograph. Is that what you want me to look at, Mr. Steele?
And Your Honor, some of these
Yeah.
exhibits, so there's the exhibit of the drive-by shooting that resulted in Mr. Thomas's death that is at nighttime.
Uh-huh.
And there's also a lit up the Texaco gas station that's like 50 feet from the crime scene location. So that Infinity vehicle, in the state's belief, is the same vehicle seen in the kind of more lit up gas station and also the vehicle that did the drive-by shooting. And so it is not as easy for just a juror to decide, because of the quality of this 2015 surveillance video, what kind of car that is driving down in
Okay.
either of these. And
So are you going to have Mr. Burnett look at the darker, more grainy drive-by and say, I can identify this as an Infinity because of X, Y, and Z things?
Correct, Your Honor.
Okay. And then you're gonna have him look at the same thing in the gas station photo and say, in my opinion, this is the same Infinity because of X, Y, and Z things?
He will speak about the make and model of the
Okay.
vehicle. He won't be able to definitively say that's the exact same
Okay.
car.
But you anticipate he'll be able to say, this is the same make and model as the one shown in here, and here's how I know that, here's how I'm able to determine that?
Correct, Your Honor.
Okay. I mean, that seems legitimate, and then obviously the jury will be instructed they can believe it or not believe it, but that seems okay. Okay. All right, so then we have Mr. Sledge and his jail call. Did we already do his jail call?
We haven't. I've listened to the jail call. I would object to the jail call. It's Mr. Sledge talking to his fiance or wife about what happened in court, and
Okay.
it's definitely
There's a
not
relevance objection?
it's not relevant. It's speculation. It's definitely not furthering any conspiracy. I'm not sure why that would be admissible.
Okay,
We would not play that jail call unless there was something that Mr. Sledge said on the stand that contradicts something that he said in the jail call.
okay.
So, I mean, that's.
So that's just potential impeachment. That's
Right.
not gonna come in during his,
Right,
Okay.
right.
all right, well, I mean, it's still out there as a impeachment if that becomes an issue. But we won't, yeah, it sounds like they agree. Okay, and is that it for Mr. Sledge? We already did his interview. So that's the only jail call.
Right.
Okay. All right, so then Mr. Zachary, and we've done both of his statements already. Jail calls and social media. Yes,
Is there an updated, can I ask the court to inquire whether there's an updated contact or address or both for Mr. Zachary? Somebody said that he's in North Carolina. I don't have any contact with that. gentleman.
Okay, can you provide, if his contact information has changed since y'all last provided it to the defense, can y'all provide updated?
So yes, so the last time before last that we spoke with him, someone indicated that he was, but it appears that he is still in
The same
same
place
location.
he was? Okay, all right.
The last week, or just for you to know if it matters to the court. Hold on, can I ask this question? We were told that he's very ill. That's what I was told from the detectives.
Okay,
And I was told that he's in a hospital. That was dated June 4th, 2024. So we haven't bothered him at all. But if that has changed, but I heard what the state said, it's
Okay.
information on the witness
We
list.
can discuss that aspect of him at the bench or something like that. I don't want to put personal information about anybody out.
no, I agree. Is that something we need to come up now and discuss?
We can.
Okay, let's do that. So with regard to Mr. Zachary, on the kind of detailed witness list that starts with Copeland at 81, all you have listed for him is the 2 interviews. On this other thing that we all got several weeks back that just kind of had the order of witnesses, you also had social media and jail calls. Is that something we need to sort through? Or do you not intend to use those anymore?
We tend to use them. We did provide the social media postings that he has.
Okay, that's in that other Dropbox, right? Okay, so let's go to that then, and sort out whether there are any evidentiary issues with regard to all of the things you think you might use evidence-wise with Mr. Zachary.
On the 8th of August.
Yeah.
We put all this in there.
Zachary folder. So we've got a group of social media, and then we have a couple of, well, I mean, we probably should just make sure while we're here in this folder that there's not going to be an issue about any of the rest of it either. But let's all open up the social media folder first. And voice any objections to any of what is in that folder so that I can take those up? I mean, I can see, everybody can see them, right? As long as we are looking at the same thing. Which if we're all looking at the same folder, we ought to be looking at the same thing. And like presumably everybody has already looked at all of this because y'all have had it for a couple of, week, 10 days, 2 weeks, something like that. So are there any objections to any of these social media postings and screenshots?
Just as a general objection, Your Honor, it's not a huge deal with this first photo, but the way we've been doing it is any non-testifying witness, if they've made comments on social media, and I'm not talking about the poster, but just other people, we've been redacting that. Again, it's not a huge deal in this case. Someone named No One Trusted says where you at, but
Right.
generally moving forward with all the social media, we're gonna ask that the state redact anything that's not said by a testifying witness.
All right, and I mean, if there is some reason why that's relevant, you can bring it up, but otherwise, I think that's a reasonable way to go about it. So that's how y'all will operate.
Yes.
Okay. All right, so beyond just that clarification, are there any issues with regard to the things in this folder? There are 23 different items in the folder. And like y'all ought to be ready to go with this. Because all week last week I said this is what we were going to be doing. So I can't tell whether y'all aren't saying anything because no, you don't have any objections, or because you're furiously scrambling to look right now for the first time, which should not be the case. Okay. It is.
going, our stance is a lot. Sorry. We, as a group, we're going, our stance is a lot of this. These are just social media posts that do not touch upon any allegations. And we're just essentially most of these cumulative, irrelevant, 403. And so I know that Your Honor maybe didn't want to do it this way, but if we could maybe just put them on the screen and litigate one by one, I think that might be easier because there's several that are objected to.
Okay, so which ones are objected to, and we'll put those, we can all look at those.
2,
Two, that's 2015-57, that one? Is that what you mean? When you say two, you mean the second one in there, right?
the second one.
Okay,
Yes.
all right, and assuming the comments aren't there, this is for all of these, unless you tell me differently, this is a relevance and cumulative objection?
It's a relevance. It's a relevance objection on this one in particular. From what I can see, it's a video. It's very dark, but I presume it's Lil D. I don't know that for a fact.
Okay, that's fine.
Yelling about Club Crucial and cussing.
Judge, this video. If the objection is relevance. So if the court was able to hear what was being said, this was a public declaration by a YSL member on his social media page that it is Big Brucial. They're at Big Brucial, which is Club Crucial. The substitution of the C in crucial for the B is evidence of what our gang experts have testified to regarding what blood gang members typically tend to do. Mr. Zachary is referencing not only himself, but slime takeover at Big Brucial, YSL. They're using YSL jargon. It is evidence of the existence of the enterprise, the existence of the nature of the enterprise, the associations within the enterprise, and the gang itself.
Okay.
Your Honor, we've beaten the dead horse of B's replacing C's a long time ago in this case. The state has played numerous videos of young men like 13, 14 years old hanging out in a parking lot saying B instead of C. And I mean, at some point, this is just,
Okay.
like, we've talked about this.
All right. So is the point of this that it is from Mr. Zachary himself, and it is relevant to his credibility as to whether you tell me,
So
why is it not cumulative?
It's not cumulative, one, because no one, I think, in here is going to concede or stipulate that YSL is a criminal street gang. So one, the associations that, and the substitutions that Mr. Zachary, who is an associate and a member of YSL, uses that tie himself and YSL to criminal street gang activity, and criminal street gang customs is relevant in
Okay.
itself. Mr. Zachary is an associate and a member of YSL who is testifying. The fact, unless they're going to stipulate to these things, to the fact that YSL is an enterprise and that this is the nature of of their behavior, of their actions, then none of this is cumulative when Mr. Zachary hasn't testified, and the jury hasn't heard from this witness.
Okay. All right. I think that it is probative to show, on the issue of his credibility and what he may know about the gang, because I assume that there might be some argument, oh, well, this is part of his plea deal and this is something that occurred prior to any of that, that arguably shows his connection. Now, if the next 22 all do the same thing, then we'll have a cumulative issue. But this is the first thing from Mr. Zachary that's not, him sitting on the stand saying it. It shows. So
He
go
didn't.
ahead.
He didn't enter a plea. He's not
Oh,
listed on the
okay.
indictment.
All right. All right. So I'm going to overrule those objections. What's the next item that y'all have?
Number 3, relevance,
Okay.
and relevance.
Let me. What's the relevance?
Judge, in number 3, I'd point out that Mr. Zachary's social media name is YSL_Lil D. He is in the picture with Shannon Stillwell. I believe that's Demikion Garlington in the back seat. Mr. Stillwell is throwing up the YSL sign. And what Mr. Zachary says in the post that is made on May 5th, 2015, all my dogs dirty, check for mange. I mean, I think it's self-explanatory, but the association, the nature of the.
I'd ask the state to explain what they think that means, because
It's not self-explanatory to me.
Okay.
I mean, all my dogs dirty might be, but check for mains.
Well, that part, the check, like you, check what, all my dogs dirty. I mean, check for mains, like mains. All my dogs being dirty is a declaration by Mr. Zachary. And we would argue that it relates to him, his friends, his cohorts, YSL members. Mr. Stillwell seated next to him, Mr. Zachary, Mr. Garlington seated behind him. It is an assertion of who they are and how he perceives them as a group. He is associating himself with them. He's saying they dirty.
Okay, well, so the check for mains part remains unexplained, but
I don't know why Mr. Zachary proclaiming all my dogs dirty would have anything to do with this case.
yeah, well, I mean, it might make something more probative more likely than it would be without. So I'm going to overrule that. It may or may not mean what she asserts it to mean too, but that's for y'all to argue. Okay, which one's next?
Number 5, relevance. And I'll just point out that we have already through 3 and 4 and 1 and 2 established that YSL Lil D is his handle at this
Okay.
point.
Yeah, so we don't need it for that anymore, but here we've got stack of money and a firearm.
I don't.
He said 5.
I'm sorry. 4. I'm sorry.
Okay, well, I'm looking at number 5. So let me get back to number 4. All right. State.
We don't need number 4.
All right, 4's out. Is 5 next, or what's the next one?
I don't, unless someone else on the team or on the defense speaks up, I'm okay with 5.
Okay. So what's our next one we have objection to?
Number 6, there's no objection, assuming the proper redactions are made. Number 7, no objection. Number 8, irrelevant, and also, so 401 and 403.
All right, let's look at number 8.
How's that help?
All right, they're not gonna use 8. I want y'all a little more ready to go tomorrow, okay? I feel like we're looking at them right now and making the determination, and that was supposed to be done before now.
Number 9, same objection. Well, relevance.
Response? And also, to the extent y'all can get together and agree like you did for a couple of the statements, that would save court time as well. Okay, see, this is 3 already that y'all objected. They said, yep, okay, we won't use that. So if y'all get together, maybe we can do more of that. What's next?
Number 10, relevance. 401 and 403.
So this, I think we may have, number 1, we may have already put in the picture, but number 2, it is the association with not just Mr. Stillwell. Here it is the witness in the elevator with Mr. Or in the photograph rather with Mr. Williams. And I believe it was Oakland standing in front of them. And this was posted January 2nd, 2015, 8 days before the Donovan Thomas murder. And the caption is at Woody 372 at SB _ living lovely at Thugger 1, a heart, and the green snake emoji for the YSL gang. So our argument is that this shows an association.
All right, I'm gonna allow that over objection. And I've run the 403 analysis and overrule that. What's next?
This appears to be actually my client's post.
I don't know which number we're looking at.
11,
Hmm.
where he's, I'm presuming, standing next to a gentleman that goes by Trouble, who I believe is deceased now and is, oh, okay, it's a different Trouble, I'm sorry. He is not deceased, but I don't know, his name has never come up in this case at all.
Okay.
So I don't know what the relevance of that would be.
Relevance.
Judge, we don't have to introduce this photograph.
Okay.
Number 12, I'm going to acknowledge that it shows Mr. Kendricks in the photo, which if they're going to argue association, that's fine, but this association is being established through 12. So I don't object, but
Understood. If the next 5 do the same thing, it'll be different. All right, so
And number 13 is relevance 403 as well. All it's doing is showing Mr. Stillwell, Mr. Zachary, and Mr. Garlington in a photo together. And this has already been, association's already been established, I think in picture number 3, maybe.
So, Your Honor, understanding that the defense feels that one picture is sufficient to establish a photo, and at some point maybe past one is cumulative, but this particular picture has a caption on it, the date of it being 2/17/2015, from top to the pen to the grave, wherever life takes us. Y'all gonna forever be my little bros at 30DD at YSL little D. Y'all go and follow them, by the way. So, Your Honor, our argument would be that the caption itself is relevant and the date of the association.
I would think highly relevant. I'm gonna overrule the 401 and 403 objections. What's next?
Number 14 is a post by YSL Buck. That individual, to my knowledge, has not come up in this case at all.
Yes.
So I'm,
All right.
oh, is that Buck?
Yes, it is. Okay. All right, so are you,
I don't know what the relevance is. Buck's not charged. He's not testifying. He was mentioned in a incident from 2013. So I'm not certain what the relevance is of showing a picture of Buck or a video of Buck holding what appears to be a firearm.
Real big bullets, bitch. We ain't play with her. Yeah, huh? That's how the boy Bills. Fuck they doing. So that's how the boy Bills, my motherfucking big bro Snake.
If you hit play, the first person you see as they're talking about YSL, Big B, little bitch, is Quindarius Zachary. So that's further evidence with the gun. It's further evidence of the association and the nature of the enterprise and the nature of the association. One more. And also underneath at the bottom, you see the hashtag YSL Real Slime with the snake emoji. This is this outward display of aggression, this outward display of, firearms. We would argue go to proof of the nature of the enterprise, the nature of the association, the nature of the gang itself, and the nature of the activities within the gang.
all right,
Your Honor.
yes.
I mean, we've been hearing that explanation for months now. The nature is, we're talking about videos posted on the internet by someone who's not charged, that has in the video someone else who's not charged, who's cussing and pointing guns, and I think they say YSL in the video, that at this point, any probative value derived from playing this video at this point in this trial, after all the other videos that have been played, is marginal at best, and it's outweighed by confusion of the issues, prejudicial effect and the like. I mean, this is, it's just overkill. And all these videos, I'm not gonna say all of them, but a great number of these videos have absolutely nothing to do with the issues involved in this case. And this is why this case is taking so long.
Well, I mean, I think it is probative of the assertion that YSL is a gang willing to commit criminal acts. Now, how many, so this is Zachary, Buck, and who was the third person? Do we know?
Not off the top of my
Okay.
head, Your Honor, but I wanted,
Buck is asserted to be an unindicted co-conspirator?
yes, and to be clear, Buck has, not only has his name come up multiple times, he has been in video, he is, his voice was played over a jail call. He recorded one of the videos with Trontavia Stevens and Mr. Williams. So yes, these two are YSL Associates members. And also, just as to the point that Mr. Sharp made about the number of videos, the constant cross-examination and sort of rebuttal against this idea that it shows an association, and the nature of the gang is that it's promotional, it's music, it's art, it's something that's not related to criminal street gang activity. So our position on that is unless there's this stipulation regarding that, which we assert that it's relevant to prove, that every time that they argue that a particular video is promotional or it shouldn't be taken literally, they are creating the need for the state to show the jury evidence otherwise.
Okay, do we have a video similar to this one in already?
No.
Do
We
we
don't
want to dispute that and point me to what is?
When you say similar, I mean, the state played.
I mean,
think
not like a music video,
the
but
state played. I believe twice they actually played it. About 13-minute video of young men talking about YSL and slime in a parking lot outside apartments.
are they pointing guns at the camera while threatening to do things in the name of YSL?
I'm being told that guns were pointed in that video.
And is it I don't mean a music
No,
video.
it's not a music video. It's a video of.
And who are the people?
It was Walter. It was Trontavia Stevens, Lil D, Mr. Williams, Walter Murphy.
But not Buck or Zachary?
Lil D, what was that? Okay, so Zachary, I'm being told, was in it. Buck was not in it. I don't know what is important about Buck,
All
quite
right.
honestly.
If y'all want to tell me exactly what, exhibit number that is, or give me that to look at, but my inclination is that this sounds different enough and not cumulative. So I can look at it and, I may change my mind, but at this point I'm overruling the 401 and 403 objections.
We'll get you that exhibit
Okay.
number. 15 is my client's undated Instagram post showing a picture of Mr. Zachary. I believe that's Mr. Zachary, although it doesn't quite look like him. I believe that's him. And he's standing next to a platter of pastries.
So I think that's a relevant subjection.
And cumulative, because the association has been shown.
Okay, what does the state say about that?
Judge, we don't have to use this initially. We believe that it could rebut a particular line of cross-examination, but right now we won't use it in our direct of Mr. Zachary.
Okay, so there may be some cross-examination about whether they went to a bakery one day, and then this might be relevant. Otherwise, they're not going to use it.
And Your Honor,
I'm kidding. I mean, it may be relevant to something else, but who knows? I don't know.
so it's Mr. Stillwell's post
Right.
of Mr. Zachary, and his commentary about Mr. Zachary is what we were looking at that was
All right.
most relevant.
He's commenting my dripping. So he's commenting on his clothes.
Dripping in blood. There's a red jacket that he has on, and that jacket, our argument is that that's what he is referring to.
Okay, well, at this point in time, we're not going to be using that one.
Okay.
What's next?
16 is fine, no objection.
Okay.
Yes. 17 is fine, no objection. 18, 401, 403, the association with my client has already been shown. Not sure, that's Your Honor, just so you know, that is Mr. Zachary and Mr. Stillwell seated behind a bottle of liquor with large amount of cash on them.
So, Judge, this is part of our indictment talks about the purpose, and hang on, I'm going to just read the language. Obtaining money as associates of Young Slime Life, the defendants conspired to associate together for the purpose with others for the common purpose of illegally obtaining money and property through a pattern of racketeering activity, including robbery, theft, and the unlawful sale of and distribution of drugs.
Mm-hmm.
This is Mr. Zachary posting large sums of money with Mr. Stillwell and asserting their unity. One thing about my brew, again, the B replacing the C, we all eating. So he's talking about,
Yeah, we're rolling in the day. We're doing well. Do we have other things that already show this that are similar?
when you say similar,
No, I don't actually think there was a cumulative argument on this one. It was relevance and 403 overruled. What's next?
Number 19 is
number 19, is that the next one?
And who all do we have depicted in this photograph?
We believe that this is Mr. Zachary, Mr. Nichols, and the third person we're not certain about.
All right, this is showing Zachary and Nichols in the same kind of YSL posts with guns.
Showing, yes.
Okay.
Your Honor, 403.
So,
Highly prejudicial, outweighs the probative value.
it does not, overruled. What's next?
I believe that's Mr. Zachary and Garlington.
Your Honor, that is who is.
Okay.
That is who is shown in this photograph.
Okay.
Number 22 is Zachary and Garlington. I don't have an objection.
Okay.
23 is another picture of Mr. Zachary and my client, Mr. Stillwell, at some sort of arcade, sticking up their middle fingers. I would object to that. Relevance 403.
All right. what's-
Cumulative.
Days, oh,
Go ahead. What's the state's response?
6 days after the murder of Donovan Thomas, this post is made. We gangster in every city we go.
All right, and this is 23, right?
25th. Oh,
20, which
yes,
one is
number
this?
23.
20, yeah, okay, right. Well, I just clicked out of it. And the main objection is 403 on this one.
And relevance. And Your Honor, while we're at it, the state said, brought up the caption. I don't know why that caption would be displayed. That's the words of Lil D. Sure, he's testifying. I guess potentially that could be impeachment, but I don't know why his out of court social media declaration would automatically be admissible.
It is the assertion, the public assertion, the fact that it is made publicly to display their dominance. This is 6 days again after Donovan Thomas. We believe that they went out of town into another city following the murder of Donovan Thomas, and an assertion that we are gangster in every city that we go. The fact that you made the post, that you put yourself out there with another YSL member in itself is evidence beyond the words that are spoken.
What rule of evidence would allow an out of court declaration by someone who's is not a statement of a defendant or a statement of a party opponent? I don't know what rule of evidence. They keep saying because he's saying they're gangsters.
I
Okay, but
assume, is he alleged to be an unindicted co-conspirator? I would think that would be the rule of evidence.
I don't know how this would be deemed in furtherance of a conspiracy.
Because it shows, number one, it asserts their dominance. It shows, it asserts their cohesiveness. We are gangster in every city we go. It promotes their, pull up the indictment. It preserves and enhances and protects their reputation, power, and territory by the posting of messages, images, videos, and songs demonstrating allegiance to the enterprise and a willingness to engage in violence on its behalf. It is literally a line that I just read is literally a line from the indictment. And so this post itself is proof of that assertion and allegation in our indictment.
All right, I'm gonna hold my ruling on that and we'll see what else we've got.
And Your Honor,
Yes.
all of these that we're going through, there has to be some sort of foundation. I mean, if Mr. Zachary says, yes, I posted something like that, then that would be bolstering, right? It would just, or cumulative. If he says, yeah, I posted that, and this is the reason why, just because it's in the indictment does not make that assertion credible. So the witness has to testify to all this before it just comes in as an exhibit. Am I wrong?
Well,
I mean,
it has
that's
to
what
be
I will be
introduced
objecting.
in some form or fashion.
It has to be introduced. That part we agree, but not that it's not permissible or admissible as an item of evidence just because he says I did post it.
Right. Okay, so I'll withhold ruling on that one. What's next?
That's all the social media in
Okay.
this folder.
All right, so
Oh, yes. What's the exhibit number? And Your Honor,
yes.
the exhibit number for that other video that's already been played states 16. Oh, I'm sorry, 60 WA.
Okay. If y'all have it handy and can just shoot it to Ms. Bursfield and I don't have to go through the former court reporter to find it, that would be great. If not, I'll try it the other way. All right, so let's look and see what else is in the folder for Mr. Zachary. There's, well, y'all can see the same things that I can see. Is there any objection to the other 5 items? I think one of them's, the last one's one of the interviews. So is there any objection to the other 4 items?
The second to the last one,
Yeah, I couldn't open that one.
I couldn't
actually.
either.
So can y'all maybe share that one? Do y'all know the one we're talking about? I don't know. It may be. It's 3.95 gigabytes, so maybe. It just seems to be in a format that.
It's an evidence review or interview.
Okay, so it's the other interview. Okay, that's fine. All right, so then objection to the other 3 items. Anybody?
items.
Okay, and you're speaking, I guess, and everybody else's silence is assent here. Okay. All right, so that's Mr. Zachary. Should we look at, is Mr. Sledge, let's look at Mr. Sledge. He's going to be either right before or right after Mr. Zachary. Okay, let's see what's in his folder. All right, we've got a jail call folder, a social media folder, a tattoos folder, and then some other items. Have we already dealt with any jail calls for him?
Your Honor, that's the one that the state said they would only play for impeachment.
Okay. And that's the only thing in that, yeah, okay. So that's all right. And then how about social media? Do we need to go through his social media? I would suspect.
Yes, Your Honor.
Okay.
Excuse me, Your Honor.
Yes.
Could I have 5 minutes before we begin the process?
Yes. If anybody else needs to use the restroom, all right, let's take a quick convenience break. All right, we're looking at the social media posts for Mr. Sledge. Which ones do we need to litigate? So for whatever reason, I don't seem to have the, let me see if I can find the numbers. They were a lot clearer on the last group. So give me a minute to find where number 3 is.
And Judge,
Yeah.
am I incorrect? I believed that we had gone over Mr. Sledge's social media post. We did not?
I don't know if that happened.
I thought that we had gone over them, some of them at least, and particularly number 3, if that's the one that's labeled State's Exhibit 397Y.
397Y. No, I've never seen that.
Where we talked about the fact that it was the night of Donovan Thomas's murder and that he was
Yes.
posting.
Yeah, I
Patriots
remember
Day?
talking about it.
Okay.
We haven't reviewed this, and my objection to this is the state keeps inserting these January 10th, 2015 captions on these photos.
We don't,
If you look at every other Instagram photo, there's nothing like that. But then on these January 10th, 2015, they're inserted, and that's inappropriate in my estimation. And that's my objection.
Sustained. I don't
Judge-
think y'all need that. That's not what it really looks like.
that's fine. And we intend to show evidence that it was posted on January 10th, 2015. So we can take out that little square that's above
A
the,
hover, yeah,
yes.
okay. All right, so that objection is sustained.
And number 4, the same thing.
Okay, they'll adjust that one as well.
That's right. And so Judge,
Yeah.
As I said the other day regarding the other inquiry about that, as I'm asking the court, if we establish with the witness who caused that to pop out.
Right. I would think that if you are having that witness testify here, here's me looking at the social media and here's what I do to find out the date it's posted and this is what it looks like. Here's, when I hover. I mean, I think that's fine and you can show that, but I think the exhibit that goes out to the jury needs to be just what it looked like, not with the hover.
So if, no objection to that ruling as to showing the exhibit with Mr. Sledge, right? Because he
Right.
wasn't the one that hovered.
Right.
But as to, for instance, ADA Sprinkle, who would have been reviewing it and who would have been hovering, screen grabbing what shows up when he is looking at a social media page is relevant, we would argue, relevant evidence of the date that it was posted that goes beyond the memory of.
All right. What does the defense say to that? Like the proposal at this point is not to have the hover part with these witnesses who posted or whatever, but with the investigator or prosecutor who I guess was in charge of collecting this evidence and who confirmed via hovering that that was the date it was posted.
If my stance, the state keeps saying Mr. Sprinkle did it. I don't know that to be a fact. So if they produce the witness who hovered,
I mean, I think that's their plan, right? Is to put Mr. Sprinkle on the stand and he will testify to that.
Sprinkle, Gaither, Dennis, whichever one, because there are multiple
Okay.
ones.
well, so that's my whole point.
So
They keep
yeah,
saying
whichever, that will have to come in through whichever witness did the hovering.
That is what we're saying.
Okay. All right. What else?
Number 5 is
Well,
I'm,
could he just,
I'm going to object to number 5.
which one?
It's
I can't tell what number 5 is. These
I'm-
aren't labeled the same way as the other ones.
on your top right of your screen. Do you have something that says 5 of 37?
Okay, yes, and they're also labeled. So that's Stacy Exhibit 399 Yankee. So that's the video. It's 39.
Okay, got it.
So
Do I need to watch the video? Because if so, I need to pick which media player
I
I'm
can,
gonna.
you can just, I can hit it. It's a regular one.
Well, I'm not on Zoom, so do I just need to
Oh,
hear it?
I think
I
hearing
can
it-
join Zoom, but I just hadn't yet. So give me just a second.
Yes, Your Honor.
Do I need to see it or just hear it?
I think hearing it would suffice.
Okay.
That's,
To feel the screen.
You lied to your mama,
I just forwarded.
but you get in the courtroom and in the investigation room and tell them punk ass people the God honest motherfucking truth. Pussy ass.
I didn't stop it. Let me try it again. It's loading. Oh, Lord.
Lie to your kids, you lie to your mama, but you get in the courtroom and in the investigation room and tell them punk ass people the God honest motherfucking truth. Pussy ass.
So
I thought we did discuss this one already.
There was a prior video that's been admitted into evidence where this is my recollection, and Ms. Williams, if this is not correct, I apologize. Mr. Williams, we discussed this one as well?
We did.
Okay.
We did. Okay, so on to the next one we didn't discuss.
I know my next one I had object to is number 11.
Okay, can y'all tell me what state's exhibit number that is?
yes.
And number 11 is, it's State's Exhibit 406Y. And to me, it seems to be a collage of other photos with Mr. Sledge and other individuals that show up in other exhibits. There's no new associations that are revealed by
Okay.
State's Exhibit 11.
All right, is the point of this one the post that goes along with it?
Yes, Your Honor. Just 1 second. We're pulling it up. You got it. Yes. Just to put on the record what it says. I love my slimes, well, snakes, and they green heart emoji me. And it's a photo grid of Mr. Sledge and other YSL members. So yes, the post and the association and the public proclamation of that association.
All right, so similar to when Mr. Zachary is himself saying, yeah, these are my YSL people and here's me with them. If we don't already have something, I mean, we may have these individual pictures, but we don't have this assertion yet by Mr. Sledge, then that is not cumulative. So that's admitted over that objection.
Number 13 has a similar caption,
What's our exhibit number for that one?
408Y.
Okay, thank you.
Has a similar caption, and it seems to be my client dancing.
Okay, so that one's a video, which I can't open. And I don't know why, even though I'm now on Zoom, I can see it on Miss Persifield's, but I can't see it on mine.
Ms. Hilton, if you could share via Zoom, that would be helpful.
Oh, there it is. Okay. I got it now. No. Are you gonna hit play?
Share the sound.
Yeah, if you want to figure out the evidence viewer.
So this is yours.
Okay, all right. Okay.
It's popping up over there.
Thanks. Okay. Is there anything added to this one that isn't captured in the, still other than a good beat?
You just created a soundbite. The still showing all of the members of YSL and the post are the most pertinent parts.
All right, so then y'all don't really need this one, right? I'm asking, is there,
We don't need the
we
video.
just looked at number, was it 11? That was like the collage. Are there people in this still or part of this video that aren't also in that collage?
Mr. Williams, I believe, but I'm checking to see in the
Okay.
collage whether Mr. Williams
All
is in
right.
the collage. Mr. Is he in there? You can't see his face in the collage. So the still shot is in the collage from the video in the upper left-hand corner, but
Okay.
Mr. Williams' head is turned away from the
Okay, so
camera
if you
in the
want to
video.
capture a still from that video that shows Mr. Williams, then you can use it.
Okay.
Okay. Next.
Number 14 is the same thing.
14 is which exhibit number? 410Y or
09Y. I'm sorry.
409Y? I thought that's what we were just looking at. Oh, well, no, that's a different one. Okay, that seems cumulative. Unless there's some reason that the state believes it's not.
These are different people, and this is, can you hit play? This is Mr. Sledge, Trontavious Stevens right there, and Mr. Williams' sister, as showing the association, as showing, again, when they're talking about, I love my green heart, green snake, red hearts, emojis. We have jail calls that we have asserted are co-conspirator statements that involve Mr. Williams' sister.
Okay.
All of these same people are in.
I don't know that this sister is the sister.
There's another exhibit, 405Y. The state, this is an unrelated trip to the club, and now we have 2 videos, a collage, and I think 2 photos
Okay.
documenting this night at the club.
Okay, so which videos are, because I haven't, unless there's some video that you just didn't.
Well, I didn't object to it.
Okay.
It's 405Y is a picture of everyone from that same night.
Okay, and does that show the sister?
I can't.
Does the state know whether the photo that's a big group shows Mr. Williams' sister?
Okay, 2 things. So I don't know that it's the same night as Mr. Sharps argued, but
Well, I'm
I'm
not sure
looking at
that's relevant. If the point of it is to show their association, then whether it's the same night or not.
Okay.
Does this show Mr. Williams' sister with this, general crowd of people?
Okay, we're going back to 405, was it?
Yes.
This group? He says States Exhibit 405.
It's picture number 10.
Okay. Can you go down?
Okay, well then, that video then shows something that's not shown already. So that video is number 14. So that's admitted over objection. What's the next?
410Y, it's some sort of meme that was shared by apparently Mr. Sledge. Makes no reference to anyone in this case.
So, Your Honor, the reason that this meme, we would argue, is relevant. You're about to get 20 years for a crime your best friend did last night. Do you snitch or take the beef? You tell the punk ass police to do their fucking job. So Mr. Sledge, in his interview, he essentially said as much. On his video that the court heard a moment ago, he intimated as much. But what he's doing in this particular posting is making a public proclamation displaying their belief towards snitching. You have not only Mr. Sledge making that lie to their mama and lie to their sister, get into court and tell the God is on his truth. You have Mr. Williams, who posted a similar video with Mr. Sledge apparently in the background, mumbling, saying, sort of signing on to whatever it was that Mr. Williams was saying at the time. We would argue this right here is more of that. This is who we are. You know, we don't snitch. You let the police do what they're supposed to do, but you don't tell on your friends. And under the circumstances of this trial, especially considering some of the testimony the jury has heard, we believe that this particular type of posting, public posting, is very relevant to explain some of what the jury has seen.
Okay.
Two things, Your Honor.
Yes.
First, the state has said they have a video of Mr. Williams saying things about snitching and Mr. Sledge saying things about snitching. So this is cumulative. Also, you know, the state keeps saying they feel this, they're saying this. Mr. Sledge owns and operates, presumably, his own Instagram account. At no point does he make any reference to anyone involved in this case. At no point is he saying he's speaking for YSL. At no point is he hashtagging YSL or at YSL, anything. He's making a comment as an individual on his individual page. And he's really sharing a meme, but I don't know why that's relevant. And it's certainly cumulative when the state just said they have other people. They have him actually giving a statement, and they have Mr. Williams giving a statement that's already in evidence.
All right.
This particular assertion, it doesn't just say no snitching. It says you're about to get 20 years for a crime your best friend did last night. So the fact that Mr. Williams has made an assertion that is very similar in nature to the one that Mr. Sledge has made, and then the fact that this particular posting references not just telling on someone, but you're about to take the heat for something your friends did. It's displaying yet another message to the public about YSL and we would argue, their willingness to stick together and stand on, you know, their loyalty towards one another. The argument, I don't know that it's so much necessary to say that it's, you know, it would be our argument that he is asserting the sensibility, the way that YSL operates. That's what we would be doing. It's proof, we would argue, it's our evidence of the way that YSL sort of.
All right. I'm going to
promotes
sustain
itself.
that objection on 403 grounds. What's next?
413. Why? Is this the same video that was was, I believe, 399 and 413 are the same. Am I incorrect?
I don't know. Are those the same video?
Oh, I'm sorry, it's a different video, but he's saying the same thing. He says the same thing twice about snitching and things of that nature.
So do I need to hear what this says?
Hey man, nigga getting to tell lies to his kids, tell lies to his mama, but get in the courtroom and tell the judge and God on the truth. Y'all pussy ass niggas. We call you whole ass niggas strip now. Flat folks.
So I think it's actually, and I think it's the same words. One time he's wearing a white t-shirt, it appears, and one time he's wearing a white tank top. I don't know why he recorded it twice.
We can just use this one, especially since he says Blatt at the end.
Okay.
Blatt, Blatt.
All right, so this one, and what's the number that you're not going to use instead?
399Y.
399Y will be out then. Okay.
And Your Honor, the other issue is that posting it multiple times, posting their feelings about snitching multiple times, it is meant to reinforce how strongly they feel about it.
All right, so what were the dates of the two posts? I had understood you to say that you wouldn't use the other one, but are you now saying you do want to use the other one?
So we would ask, yes, to use both
Okay.
because if one is on July 19th, 2015, and the other one is on 399 is on July 19th, 2015. And the other one is on March 25th, 2015. We would ask to be able to use both.
Okay. Well, I mean, that does show that this isn't a one-time thing. I guess at least this guy wants to reiterate it. So I will admit that then. What's next?
416Y. Relevance.
What's the relevance of this?
Get it now. Ooh.
So who all's in that?
Martinez Arnold, Diamante Kendrick.
I mean, I can see the relevance. What I'm wondering is whether it's cumulative. But Arnold and Kendrick, I don't think we've had any, at least in what we've reviewed so far, the two of them.
They've both pled together on a count in this indictment. I mean, there's going to be absolutely no. No, not on this indictment, but there's a count in this indictment,
Right.
in an overact where they both pled.
Yeah. No,
So-
yeah, no, I'm saying we don't have any videos or photos that we've at least looked at today that have the two of them wearing YSL garb together, right?
I don't think we have.
Okay, well,
We have. Not so far.
okay. Anybody dispute that?
I don't believe so.
Okay, then that will be admitted over objection. What's next?
Number 22. It's another video that I don't see the relevance.
Okay,
417Y.
Thank you.
Bitch, we out doing a little shopping, bitch. How we having this shit?
I'm gonna make folk be pumped. Tell them I said we can go make a folk, man. We doing a lot of little shopping. How you doing? Fucking up Chicago. Chinchilla in the shop.
Yeah, turn up.
So that was the extent of that. Was the court able to see it?
I mean, tell me who all's in it and
It's
why
Miss-
it's.
Shannon Stillwell, Diamante Kendrick, Antonio Sledge,
Mhm.
and this is a couple of months after Mr. Thomas's murder. Diamante Kendrick is in the coat that he is wearing the night of Mr. Thomas's murder. And they are still very much associating with one another. One of the arguments that was made the other day by, I believe, Mr. Sharp was he objected to part of the factual acknowledgement of Mr. Sledge and argued that he would have had no basis for personal knowledge of information that had happened on a particular night.
Okay, well, this might show that as a foundation, but that's not for the jury, that's for me. So,
No, I'm just, as far as relevance goes, it would be relevant for those purposes.
We've just seen.
Co-counsel is emphasizing that jacket being the jacket that he was wearing. Mr. Kendrick, if we need to rewind it, we can show you.
I saw it.
Excuse me, I don't believe that's the same coat. I believe it's arguably similar, but I don't believe it's the same coat.
How do y'all know what he was wearing that night anyway? What evidence is in or gonna be in?
It's on video. He's clearly walking into a store that's a few 100 feet away from
Okay,
Mr.
and that's clearly him? And so what does it matter that he's wearing the same coat later? It's his coat. I mean, why does that matter?
No, just
I mean, seriously.
in terms of one identification, I understand that the court is saying you can see him clearly on the photograph in the surveillance video, but also he's with Mr. Stillwell, who is also alleged to have committed the act with him 2 months afterwards, and he's with Mr. Sledge. So when Mr. Sledge gets on the stand and tells the jury, or whether he does or doesn't acknowledge that he knows.
All right, well, so then this might come in as impeachment evidence, but I'm not hearing. Like, oh yeah, no, we never hung out, or we didn't hang out after that night because I was appalled at what they supposedly did, then yes, but otherwise.
And also, I think, and Mr. Kendrick filed an alibi notice as well regarding where he was at the time of the murder, so.
Okay, but this has no relevance to his alibi.
Not directly, just that it's further proof that that's him in the video and him at the location and him right there 6 minutes before the murder.
Okay, so then back to the coat being the thing that matters then.
Yes.
I guess if your client, Mr. Weinstein, is saying I wasn't.
He's not denying being at the gas station. It's in
Okay.
the video. You can clearly see that he is
Okay,
walking
so
into the gas station.
What's his alibi? Then maybe I'll need to go look up the alibi notice.
He was with Miss Morton later that night.
So it doesn't cover the time of.
No, he was with Miss Morton at the time of the murder.
Okay, what
But
time?
what the coats have to do with this, I have no idea.
I
And what a
guess
March video has to do with his
it's
alibi
some-
on January the 10th.
Right.
The
so
time he was
what's the time of the gas station video?
at the time, it was at the time of the murder. It was 6 minutes before the murder.
Okay.
Your Honor.
No, hang on just a second. Sorry. And then Is Mr. Kendrick's alibi that I may have been at the gas station 6 minutes before, but 4 minutes before, through the time of the murder, I was with somebody else somewhere else?
Correct.
Yeah.
Give me 1 second. Commissioner, I'm
Okay.
sorry. Yeah. Yeah, again, there's no denial that he was at the gas station prior to the murder.
All right, but not, okay, so the coat doesn't add anything to that.
But it's not the same. He's like my wife, Your Honor. He buys the same style coat, but it's not the same.
Whether it's the same coat or a different coat,
Yeah, it's
it
irrelevant.
doesn't show anything about
No.
the viability of his alibi. And anything else before I exclude this one? No. Okay, moving on. That one's out.
23, Your Honor. The previous photos have 418Y have
Okay.
continued to show an association between Mr. Sledge, Mr. Zachary, and Mr. Stillwell. That's been established through the photos already.
All right, and who is this we've got right now?
That is Mr. Stillwell, Mr. Zachary, and Mr. Sledge.
Go ahead.
I would point out the caption that Mr. Sledge makes underneath the photo, gangsters sitting at the round table with 3 green snake emojis on March 4, 2015.
And those same emojis are what justified all these previous.
Okay, so are you making the argument gangsters sitting at the round table is like a reference to King Arthur and the Knights of the Round Table, or what? Or
No.
just the fact that they're saying gangsters?
That they are calling themselves that he is calling them gangsters, because I believe at some point there will be, we've heard at least one witness while we were talking about gang say game, like GAME. So I believe that there may be efforts to distance YSL members. Well, there have been consistent efforts to distance YSL members from being gang members, gangsters. So we would argue that he is not just sort of making this, oblique reference. He's proclaiming for the public something.
The generic term gangster is propensity, first of all, but secondly, if Mr. Sledge says something on the stand that's vastly is shocking to the state and they feel that this contradicts it, then perhaps there's another discussion. But in and of itself, until that happens, I don't know why this would be relevant to anything.
So remind me, the one that gangster in every city we go, that would show the same thing.
You didn't keep it in.
I
believe.
didn't rule it out. I
You
held
didn't.
it.
We would prefer
So-
this one over that one.
All right, then that one will be
hold
out and this one will be in then, but they kind of get to the same thing.
So, Your Honor, could the court give me?
Sure.
Okay. If we're going to choose, we would choose the one closer in time to Mr. Donovan Thomas's death. So we would cede this one. If
All
the
right,
court-
so then 418Y is out. And if it ends up being some kind of impeachment evidence, just sort of alert us before we use that.
Okay.
Okay. What's next?
Number 421Y, which is number 26. It's another group photo.
Mm-hmm.
This is a picture that's in our indictment. I believe we may have even already admitted the photograph, but the caption is also part of what is important. So both the photograph, the caption, and the fact that it's in our indictment alleged as an overact.
What do you mean alleged as an overt act?
The posting of that photograph was
The
alleged as
posting
an
is alleged
overact.
as an overt act.
Yes.
Okay. Then, and so, okay, you allege as an overt act that they post things that promote YSL, and you showed this picture as an example, and this is showing that it was actually posted. Is that the argument?
Yes.
Okay.
I think that.
And it's the cap.
Yeah, I can see what the caption reads. I'm gonna permit that one.
Okay, now here is and when I say here, I'm talking about 422Y
Okay.
is the actual post that does not involve anyone hovering over anything that says a date.
Right.
And I know the relevance of the date and the time. And so I don't have any objection to that, but that's the way I believe that these, not some manipulated timestamp on the upper right, but as it appears in Instagram. And so I don't have any objection to 422Y, but going back to that other
Right.
exhibit, which is 397Y, I would say 422Y is more appropriate.
Okay, and it actually, you can see down there at the bottom of the post, a time and a date.
This is exactly like when we were talking about the other day where we had the picture with the pop out of the one we dealt with on Friday.
Mm-hmm.
We had both the pop out and we had the date and time. When I referenced to the court, we had both. So this is the same situation. So we would be introducing this one, and since it's no objection, we wouldn't have a need unless there's this argument about what date it really was posted to show the other one.
Use the other one. Okay. All right.
So this next one, which is 423Y, that caption is already on 420Y. It appears that he's reposting something that some other individual who I don't know who he is, and I have no reason to believe that he's in this case, SMM body count with an X instead of a C, posted. And if you go back to 420Y, I believe, you see the exact same, I'll never switch up on my brew, I'm not a dub. So that seems cumulative, and quite frankly, I'm not a big fan, and I believe it's prejudicial to have a post by this gentleman, SMM body count, who we don't even know who he is.
What's the state's response?
I'm looking at the. That's fine. We don't object.
Okay, so they concede.
Or
that
concede,
They will
yes.
not use, what is it, 422?
423.
423Y? 423Y. Okay. Thank you. Next.
So I believe that this is a cumulative,
Which one?
I'm sorry, 426Y, number 31, photo 31, is a cumulative of the group
Hang on, that
photo.
one doesn't open for me. Too many things open. Okay, yeah, it looks like the same thing.
That's a cumulative of 405Y.
We're gonna put up both.
Okay.
Okay. We won't use both, Your Honor. We'd ask that the court allow us.
All right, well, choose now so that we know which one.
Choose the one that is 405Y.
Okay. All right, so they will not use 426Y.
Oh, wait, his phone.
Okay,
Okay.
Don't understand the relevance of 427Y.
so there's a relevance objection to this one.
It's that he listed his phone number, and his phone number by I mean, Mr. Sledge.
Okay, so if he refuses to say what his phone number is or was at the time,
Or we could
then
refresh
you'll
his.
use it.
Right.
Okay. Which you could certainly just use it to refresh his
Right.
recollection. Okay, so that'll only be in that eventuality.
Or if he doesn't remember even after looking at it, then we would have to use it.
Sure. All right, any others? We're almost to the end of this grouping.
Yes, Your Honor, 430Y, which is number 34.
I don't see a 430Y, but okay. Go ahead.
I just asked her husband she was dead. I just asked her if she was dead. She don't even know who dead. She like, you crying.
Who all do we have there?
Don't we have Mr. Williams? We hear the reference to King Slime. Could you play it back again? Sledge right there, Mr. Williams right there, Mr. Arnold, Mr. Stillwell, and Mr. Kendrick,
I just asked her husband she was dead.
Darlington, and Kendrick,
All right.
and Copeland. Oh, Miss.
And when's this from?
This was from.
And also whose account? I'd be interested.
What, I couldn't hear what you said.
I'm not sure we know whose account it's from either.
We have it from YSL_Daniel 1.
Who is that? So I, the justification is for these videos has been, oh, it's showing promotion. And we don't even know who posted this.
But we have people who are in the video who can talk about the video. It's what's happening in that scene itself.
They're sitting at a table.
That he can lay a foundation for it.
Who, and this is going to be Mr. Sledge that
Yeah.
testifies to this?
Yes. And it's in this particular instance, this isn't so much as them promoting their violence. This is them referring to, we believe Mr. Williams is King Slime. This is them, all of them. I don't know that we have these particular individuals all at one time in a setting together. And we believe and can later confirm that it is Mr. Williams' Sky House condo, but
Okay.
we'll confirm that.
Okay. I would think that would be relevant. All right, so I'm going to overrule the objection to that. What else?
Just 30, 404Y, which is number 37.
And let me say, let me go back to that one for a minute. Sorry, since y'all don't know who posted it, I mean, if you figure out who posted it, that's one thing, but if not, we don't need to show the handle or whatever of whomever the poster is, okay?
Yes, Your Honor.
All right. Okay, now back to the next one.
It's the last one, Your Honor, 404Y, number 37.
All right. Have we already talked about this one? Oh, this is,
Stop putting me on fucking fake pages. Cause I don't give a fuck, man. What y'all say, what y'all do. Anybody want to see Monto? I'm here. I don't hide. And I do not run for fuck niggas. You did.
So, Judge, this is the day after the Adele Drive shooting
okay.
that Mr. Sledge and others were convicted of.
What's the objection?
I'm going to withdraw my objection.
Okay. All right, so that is that grouping of social media. I think I might have to go back and get into that Dropbox again. I don't see it All right, the next folder is tattoos, is what that folder is called. Or do we have objections to anything in there? I mean, looks like a lot of them are the same picture over again. So at least I would think half of them, we don't need the same thing twice.
We wouldn't be putting in
Okay,
multiple pictures.
beyond that, any objection? I mean, I assume he's gonna testify that all of these are somehow gang-related tattoos or what? Because if they're just art, then that's not relevant.
We're not going to put in all of them, just the ones that reference or pertain to his. I mean, he'll be here, so we may not
Right.
even put him in at all. He can show the jury.
Well, I don't think I want him stripping down in court.
Not
so.
all the way.
So if he wants to show us what on his forearm, that's one thing. Otherwise, I'd rather let's use the picture, okay? I don't know. I can't get an answer to that. Do you know which ones you're gonna intend to use that you believe are relevant to an issue on trial here? That he can't roll up his sleeve and show us? Are these videos? Are these videos or stills? Yeah.
I think we're not gonna need to use Mr. Sledge's tattoo photographs.
All righty.
And yeah,
Okay.
I don't think at this time.
So I don't know what that, then there's an image that is, oh, it's a video that isn't in the other videos. What's that one? Is there an objection to that one?
I'm sorry, Your Honor, I just messed up my. Your Honor, can you direct us to the video that you're speaking of?
I mean, so I opened up the Dropbox and, you know, went to Sledge's folder, and then within that folder,
Okay, I'm sorry, I just clicked on it. I think that's the video. Is it the image?
yeah, 0156, whatever. Yeah. So is that objectionable?
No.
Okay. Any of the other items in that folder? And they're marked with exhibit numbers.
Is the court asking whether, oh,
I know that the state's position, I assume, is y'all intend to use those and believe they are admissible. So I'm asking if there an objection to them.
So the plea agreement, I've already
Okay.
spoken about that.
Yeah, and so, yeah, it's a little more helpful actually when I looked this weekend to see what it is y'all are talking about. And I would think whether that comes in or not depends upon how that witness testifies. So
When you're saying that comes in, are you speaking specifically?
this, I'm looking at the, whatever it is, December 27th, 2022, several page. It's called plea agreement, but he's initial different factual assertions, and that's the one I'm talking about. It's 396 YC, Y Charlie, Yankee Charlie.
Yes, Your Honor. And the terms of the plea
Mhm.
obviously are fodder for cross-examination.
Right.
I would concede that potentially, depending on his testimony, statements that he acknowledged that would be inconsistent with his testimony could possibly be prior inconsistent statements. I would concede that fact. So I agree with Your Honor that to deal with the admissibility of the factual acknowledgement section, we would need to hear his testimony. My specific concern dealt with number 8, and just as I had concerns about Mr. Zachary and Mr. Copeland, whether they were in their prior statements, whether they were speaking out of actual firsthand knowledge or if they were speaking out of inadmissible hearsay or rumor or speculation. I don't want Mr. Sledge to be cross-examined or to be impeached with a prior statement that was based on that the basis of it was inadmissible to begin with. That's my concern.
Well,
And all I can say, and I'm not Mr. Sledge, so I cannot answer this for Your Honor, but I can say from my understanding from working on this case, that number 8 is not based on anything that my client has told him, and it's not based on firsthand knowledge.
I think that may just be something you'll have to explore because he initialed and signed a sworn statement saying, I personally know this. Maybe he doesn't personally know it and it was a lie, but I mean, they've gotten that there for a reason. And that's just going to have to be something y'all explore with regard to his credibility. You know, I mean, he is right here asserting in this document, I do personally know it.
Well,
So,
I understand what you're saying. And, you know, these are not, I understand he signed it. He did not write it. And so personally, knowing to a layman can mean a lot of different things.
Yeah, he had an attorney at the time, right?
He did.
Yeah, so I think that, yeah, that I can't keep it out on that basis. All right, what else?
We briefly discussed the plea transcript. I don't know under what circumstance that would be admissible.
I would think that would also be a impeachment item, right? Would y'all only intend that for recollection or impeachment? Okay,
Okay, and then we also have a gang profile, which is filled out by someone. I don't know who wrote this. I don't think we know. We've been given a bunch of these. I don't know if we know who wrote any of them, but it wasn't Mr. Sledge.
right.
So
We would not introduce the gang profile as an exhibit through Mr. Sledge. We may use some part of it to refresh his recollection or something like that. It would be, because it would be a document that details certain incidents that involve Mr. Sledge. And it has photographs of him in
Okay.
it. We wouldn't be just whole hog introducing that.
All right, so this is not gonna go before the jury.
Right.
Y'all may
We would,
potentially refresh his recollection
It's just that-
over something like this. Okay. All right. Okay, that takes care of these Sledge exhibits, right?
I believe so, Your Honor.
Okay, so who do we move to next then?
Listen.
Sorry, I have to keep reopening the Dropbox for some reason. Is there anything with, I know, looking at the witness list, we've talked about Burnett, Sledge, and Zachary now. Thorpe's gonna be moved to a bit later, so Bean,
Not yet, Your Honor. There was one that we can talk about that I think merits conversation.
okay,
So Mr. Kendrick pled guilty in 2015 when he was arrested with Martinez Arnold in October 2015, where they had the two guns, one of which was stolen. In the plea colloquy, the prosecutor, as a factual basis, asserted that YSL is a gang and that Mr. Kendrick is a member of YSL. And Mr. Kendrick acknowledged that
okay,
and agreed to that. And so we intend to introduce evidence of that against Mr. Kendrick during the trial.
okay,
We're absolutely going to object to the entry of not only that colloquy, but any plea that reflects a gang charge that Mr. Kendrick pled guilty to. Mr. Kendrick, to my understanding, I mean, that's a decision he's going to make, but I have no expectation that I'm going to have the opportunity to cross-examine him. It was a testimonial statement. He was in court. speaking to law enforcement for the purposes of securing himself the best deal possible. And certainly his acknowledgement, admission, or his testimony, I would say, is what it is, out of court testimony, or out of court testimony as applies to this case, affects my client. A element of this whole case is whether YSL qualifies as a criminal street gang under the law. Mr. Kendrick provided testimony to that, that I will not be able to cross-examine. And so we are going to object to any entry of the plea to any gang count and any colloquy during the plea regarding the nature of YSL, according to Mr. Kendrick.
And Your Honor,
Go ahead.
the court can limit the jury to consider that against Mr. Kendrick only.
Go ahead.
That would be wholly insufficient to protect the rights of Mr. Stillwell and the others, quite frankly. A curative instruction or a limiting instruction is not going to suffice. And the state can try to prove their case, but they cannot try to prove their case with Mr. Kendrick's statements during a plea.
Well, I'm not sure that's true. I mean, if it is admitted only against Mr. Kendrick and I am Kendrick's, and I tell them that that's all it can be considered against, we'd have to craft the right instruction. But I mean, it's out there and it's evidence. And I mean, I agree it's testimonial, and so it shouldn't come in against anybody other than him. It can't come in against anybody other than him, but seems that it ought to be able to come in against him. Are you saying there's just no way to limit it?
Go ahead, Mr.
Yeah, and I agree with Mr. Shart. That is asking a jury to climb a steep hurdle. And that's why Bruton says that, yes, you can limit the statement. It used to be, as the court may remember, on a Bruton issue, if Mr. Kendrick made a statement, he made a statement in this case on October 6, 2015, and he implicated Mr. Stillwell, or he implicated Mr. Williams, et cetera. It used to be that there was an instruction given, going back to common law, that it can only be used against Mr. Kendrick. And the court said that's not good enough. In a joint trial, the jurors can't be expected to follow that instruction. It's you said it earlier too. Presumably the jurors follow the instruction all the time. That's what we presume. But in Bruton, that's why we excise or redact.
Right.
And here, it is an essential element of this conspiracy in count one and several of the gang counts that YSL is a criminal street gang. And now you have, and that's what I was saying before, and I'm looking for the cases.
Right.
But for Mr. Kendrick to get up and say, not get up, but for his plea colloquy to say, I am a member of YSL's criminal street gang, that instruction has to be airtight. Otherwise, he needs to be severed.
I mean, I agree that the instruction needs to be airtight.
Or he needs to be severed, or it's excluded. And I gave you a case when you first came on the bench here.
Mm.
I gave you, if you remember, if you don't, I could give another copy. United States versus Vendetti, V-A-N-D-E-T-T-I. I gave it to everybody, or at least the sound court in the state. And I think Mr. Weinstein, it's 623 F second 1144. It's the Sixth Circuit. It's 1980. It's good law. And I also cited State versus Jefferson, which is 30 Georgia 435. That's 807 Southeast 2D 387 2017. and they just stand, and it's State versus Thomas, THOMAS, 364 Georgia PO 148, Division 2, 874 Southeast 2D 195, 2022. But the bottom line, Your Honor, is I would agree with the Honorable Maxwell Shart that a instruction for that type of, that is explosive evidence that goes directly to the essential elements. So I do not believe that instruction would cure any type of fair trial for the other people in this case.
Just briefly, Your Honor, we would object to any severance at this point in time in the case.
All right. I mean, I've read Vendetti, and I don't think that it actually stands for the proposition that you're arguing it for right now. I looked at the other two as well. The guilty plea of any non-testifying co-defendant can't, it's not proof of guilt for any of the other co-defendants. I mean, I agree with that, but that's not what it would be offered for. Y'all, the state, need to come up with an instruction that you believe will insulate the admission of the plea colloquy, the part that you intended, where if he says, yes, YSL is a gang and I'm a member of it, from any Bruton-ish type problems.
Yes, Your Honor.
And we need to do it at, before that's admitted, not just at the end of the trial. It needs to be provided to the jury at the time the evidence is admitted.
Understood.
But I mean, I don't think that the law provides that it needs to be excluded, just that it needs to be appropriately limited. And if you can find other law, please forward it to me. But I don't think those three do it. And let's see. So Thomas, give me those two sites again. Just let me make sure I wrote them down correctly. I think you said 302 Georgia 435.
Yes, that's State versus Jefferson,
Jefferson. Okay.
2017, and then State versus Thomas, 364 Georgia PO 148, Division 2.
Yeah, got it. Thank you. Yes.
May we offer as well Henderson, just for the court's consideration. Henderson v. State, it's a Georgia Supreme Court case decided August 21st, 2023, 317 Georgia 66 at 77.
Okay. Is that a new one, or have y'all given me that before? Okay. All right, I'll take a look at it. Okay. So you think y'all may have? All right. For a different reason. Okay, well, I'll take a look at it for this reason. All right, so we're going to need to do some work on that one, but those are, I think we understand the parameters. Okay, so I don't know what, I mean, thank you, whomever raised that, but in terms of going through what other groupings of evidence we need to look at in this first 30 witnesses. the next witness that is on y'all's list in order, generally in order is Mr. Bean. Is there anything from him that we need to look at? I think, yeah. No, okay. So no social media from him? I didn't even see him in this folder, but. No, okay. And then there's Kenya Morton, and there's maybe an interview from her. I don't know if you.
Her interview would not come in
Okay.
unless she's listed as as the alibi witness for Mr. Kendrick.
Okay.
And we wouldn't be putting in her interview unless it was to impeach her.
All right, so we don't need to look at any evidence that's going to be used with her, right? Okay. Then Sprinkle, is there anything we haven't already talked about for him that? So he's got a folder. If y'all want to open up his folder. And then within his folder are lots of folders. So hopefully the defense has, in the couple of weeks they've had the folders and months that I guess they've had the evidence, made a determination as to what, if anything, y'all would be objecting to in this grouping of evidence.
I do have objections, but there's a lot here, so I don't. We can discuss certain things as Your Honor sees fit. I will say I do have objections in this folder, though.
Okay, well, now's the time to go through them while we have some days without our jury.
Yes, Your
So
Honor.
let's dive in.
Okay.
Where shall we start? We've got an Arnold file, or two Arnold files, Garlington, Kendrick's, other items, Stillwell, and then some, I don't know, looks like pictures maybe. Let me ask this. Is there something that y'all are more ready on, and then we could dive into this tomorrow? Would that help?
There. Could I discuss?
Sure.
Finish, we can make an announcement on the Marquavius Huey motion in limine, so get that off of our. to-do
Okay.
list.
We'll wait till after they confer.
But if we just step this also.
Sure. Why don't we just take a quick recess? That way, if anybody needs to use the restroom, y'all can talk. And if anybody else needs to use the restroom, they can go use the restroom. Okay. And Okay, before we move on to whatever we're going to move on to next, somebody kindly sent me the state 60 WA, I guess, that's already in. And I've only gotten through about half of it, but so far I don't see how the item number 14 from Zachary's folder is cumulative of what is shown in that video. And it may be in the part of the video that I haven't seen yet, but can somebody pinpoint for me? Can we pull it up and maybe y'all can tell me what part of that makes this other potential exhibit cumulative?
Hey, baby.
And I do not want to watch the whole video. I mean, I just, what's the part that the defense is contending makes Zachary's exhibit, I don't know what the exhibit number is, but the item number 14 cumulative? Yeah.
Recollection is, you asked if there was another video that showed the display of handguns and quote unquote gang associated
Right.
verbiage
Right.
and things of that nature that tended to show associations with whatever we want to call YSL,
Right.
using the word slap and slime and things of that nature, and displaying of handguns.
Mhm.
And that our point was that the state has admitted, I believe this says 5 minutes long. I remembered it being longer than that, but
Oh, it's longer than that.
Oh, okay.
Because I watched it for
okay,
5 minutes.
yeah.
Version, so the what was omitted was shorter than the original
Okay.
version.
Well, that's merciful for the jury.
Right. So, I mean, my point was, we've had these types of videos introduced before. My intention was not to suggest that it was identical
No,
or
no, and I know that.
exactly
But I
the
mean,
same.
I wasn't seeing a whole lot of like guns in the front of the camera kind of thing. And this, they're just standing around in a parking lot saying things and what have you, but
And the only portion that I believe has a gun, one of the co-conspirators, Walter Murphy, I think the line is, he just got out last night and he keep the strap on him and he lifted up his shirt, but he didn't point it at the camera. He just lifted up his
well,
shirt.
and maybe I didn't get to that part of it yet, but let me go back and look at the item we're talking about again, but it seemed much more kind of the whole point of the video. So sure. Yeah. I mean,
My whole crew got blood.
That's why I said Lil D, bitch. Slide shit. Yeah, ho. Ride motherfucking plane, ho. And we have real big bullets, bitch. I don't even play with her. Yeah, ho. That's like the boy Bills. Fuck they doing. So that's like the boy Bills, my motherfucking big bro Snake.
yeah, I'm gonna allow that in.
Yona, did you receive 2 videos or just 1?
Just now of the 60 whatever.
Yeah, 60 WA, I think it was,
I
but
think
there was a second one that was sent as well that actually had.
Okay, now I've only looked at one of them.
Yeah,
How about we look at the one that was one of them redacted and one unredacted, or are there 2 different?
No, there are 2 different videos.
So one with 60 WA.
Yes.
What's the other one? Whiskey Alpha. I need to get used to that.
It was a state's exhibit. I don't know offhand
All right, hang on.
the exhibit number.
It's on a Google Drive. Oh, yeah, no, I'm just now getting that. So, if that went to, I mean, I guess I can pull it up, but I don't seem to be able to play the sound. So do y'all want to pull those two up? Because I guess they're now contending that.
Yeah, and just to kind of lay the groundwork a little bit,
Sure.
Judge, the second of the two videos that was sent show, it has Mr. Williams with a handgun. It has someone named Mondo. It has Buck Buck, the person who was referenced previously, who has a handgun displayed in the video, and it also has another person you've heard the name Fatty outside of a house. It's a shorter video, but it has the images that the court.
All right, well, let me take a look at it.
Yes.
Oh yeah. Real fucking bleed, aka bleed, nigga. Yeah. Man, but mud, do this every day. Miss like they kitchen, no, that kitchen and the GI. I told him, put on the camera, talk like that. One on the chest, man. Yeah. You keep a shit on the shit on nigga. Please you fucking do it. Oh, so that nigga not playing. Real like I step up, you know what I mean? Nigga, real. And we keep fucking there. Not real slide. Keep fucking there. Real like you got by. Is you fucking there? Get her back up there. Have a little time. Get her back up there. Get her down like this. You have the time. Yeah. You're talking about everyone you fucking at, man. Like that up. You niggas going in and watch the fucking nose. Straight like that. And then what? At the end of the day, nigga with the camera got the pussy too. Let me grab it. Yeah, niggas, the kid thug. Hold on. Show y'all we gonna like, yeah. Yeah, we bullying, nigga. Don't do it. You ain't slime, you not my fucking kind, nigga. Yeah. It's slime love all the fucking time. It's fucking good. Just the lifestyle. Yeah. What you doing? Straight like that, folks.
All right. I don't find them to be cumulative, that there's one small part of that where some woman holds a gun. I don't think that that's really the same as what's shown in the item number 14. So I'm gonna stand, my ruling stands on that. I appreciate y'all sending those over there for me to consider. Okay, so are y'all ready to dive into the items that would come in with Mr. Sprinkle? Or do you want to move to something else and come back to that? That's what y'all were huddling about, I think.
Speaking for the group, I believe the preference would be to discuss the state has noticed a number of intrinsic acts.
Okay,
I think the group would like to discuss that. If
that's
it's all the
fine.
same
I mean,
everyone
we got to
else.
get through all of it, so I don't really mind if we do it in a different order. Okay, let's do that. Oh, and actually, Miss Hilton, you had said you wanted to put something on the record about, I think, Mr. Huey's motion limine about the, I assume it was the one about the photo ID from the deceased witness. Okay, what's your announcement?
Your Honor, the state does not intend to introduce that photographic lineup
Okay.
or the interview itself. The state would ask if a photographic lineup occurred and would ask if Mr. Howland was interviewed, but not the substance of what happened with either of those. Right.
Okay. Does that cover it?
So Judge, good afternoon. It does cover it, Your Honor. I'm concerned on asking the question of whether or not one was occur would make, I don't know that that would be necessarily relevant, or kind of implies that perhaps there was one, but we're not getting into it. So I'm not sure the relevance of asking that question. Maybe the state can shed light on that.
Sure, Your Honor. I believe that we still have to show the credibility of our police officer conducting an investigation. And so I think that it'll be relevant that he conducted an investigation. That was a part of the investigation.
All right.
So Judge,
Yeah, there's often an argument that the police didn't do a thorough investigation. They already had people targeted, and that's all this is. So if, to the extent that it might go to combat that, then I will admit that over the relevance objection. That I will permit that question, and the rest of it, there, concede should stay out.
so they're not going to ask, they'll ask that question, but they're not going to ask about whether or not there was an interview of Mr. Holloman.
Well, I think what she said she intended to ask was, did you interview him?
Yes. Did you interview him?
Interview, and whether or not there was a photographic lineup.
Are you going to ask that? I would
didn't hear
think that that's not, we should probably stay away from that.
I didn't hear it because of the mic.
Are you going to ask whether there was a photographic lineup with him, with that witness?
Initially I was, but based on what the court just said, no. Then I'll just ask, was there an interview? And then we
Okay.
leave it at that.
That would be the far safer route. Okay. Okay, so y'all want to move on to intrinsic acts. Okay. Which ones? Because there was a set that y'all said there just hadn't been a 403 analysis on yet. And then there was, I guess there were a few that at least somebody, Mr. Ryan was maintaining, were not really intrinsic.
Yeah, yes,
Okay.
Your Honor. That's accurate. Back in 2022, the state filed a general notice that they were going to introduce intrinsic evidence.
Mhm.
We then got a witness list on July 31st, which I think was supposed to be one of the final, we can rely upon this witness list. And within that, there were 4 incidents which happened in 2023. So they, 1, post date that notice, 2, they post date the indictment. So we've
Mhm.
never received any sort of notice from the state saying we are seeking to admit this as intrinsic. However, that is what it is labeled as
Okay.
on the witness list. So that those
All
4
right.
are what we take issue with.
Okay, got it. And these are the incidents that occurred in the jail generally?
One in the jail, 3 in the courtroom.
Okay, thanks.
And Judge, I think, I'm not sure if Mr. Bassi realizes that we did notice 2 of the ones that occurred in the earlier part of 2023. The stabbing of the person in the jail by Mr. Ryan, Mr. Blaylock, and others, as well as the violation of the Georgia Controlled Substances Act by Mr. Williams and Mr. Adams. And those 2 occurred on January 31st, 2023 and January 18th, 2023, respectively. The filing that we noticed the defendants of those on was November 6th, 2023. There were 2 additional acts that occurred in 2023 during the time that this case has been ongoing. And one was the drugs that were found in Mr. Stillwell's cell. And we've noticed some of the pictures of the drugs and the other contraband, and the marijuana that was found in Mr. Ryan's pants when he was searched in the courtroom.
Mhm. Okay, so the stabbing, that occurred in the jail, right? Okay, and then the VGCSA violation was in court?
It was.
Obviously, drugs in Mr. Stillwell's cell was in jail,
Jail.
right? And then the marijuana in Ryan's pants was in court. Is there another incident that occurred in court?
Not that's on here.
Okay. Ms. Abassi, you had said 1 in jail, 3 in court.
I'm sorry, Judge, that,
2 in jail, 2 in court. Okay. Okay, and the argument as to each is that this is not really intrinsic?
yes, Judge.
Okay,
It doesn't fall into any of the 3 categories which would classify it or qualify it as intrinsic.
okay.
Here it is.
Let me pull out my case law on that. Which. let's do that. All right, what's the state's position on why and how that is intrinsic?
The Bussy stabbing, which is the one I'll start with, Your Honor, involved YSL.
I'm sorry, what'd you say? The what?
Oh, I'm so sorry.
I just didn't understand what you said.
Understood. The victim in the January 31st stabbing, his name is
Okay.
Harold
All
Bussy,
right.
and that's what
Bussy,
I refer to it as. So that stabbing involved several YSL gang members stabbing an inmate at the Fulton County Jail who was alleged to have messed with Rodelius Ryan's commissary. It involved, among others, Demise McMullen, Javon Fleetwood, Christian Eppinger, Damone Blaylock, and Rodelius Ryan. They all, in concert, held down this person and stabbed him repeatedly, all to protect and to vindicate something he had done to one of their fellow YSL gang members. Is the way that I
Okay.
see it. So that it seems just, it's what we've alleged in the indictment that YSL members do. They work to maintain individuals ready and willing to preserve and protect the reputation, power, and even the territory of the enterprise through the use of violence.
Okay, I understand.
With respect to the law, we would cite Johnson versus the state, a Georgia Supreme Court case decided September 21st, 2021, cite 312 Georgia 481. And we cited this last week. The Penn site is 491 to 492. In support of it. Okay. With respect to the January 18th violation of the Georgia Controlled Substances Act, this is 2 YSL members on trial for conspiracy to violate the RICO Act through drug distributions, drug use, drug possessions. And while in court on trial, they are passing Percocets one to another. And we argue one to the alleged leader of YSL while in open court. One of the assertions that we make regarding the conspiracy. We have contraband in the jail. We have stabbing in the jail of YFN Lucci. We have communications in the jail. These types of actions on the part of the defendants are the type of actions that we have alleged in the indictment, and it shows that the enterprise flows from the streets to the jail to the courtroom, and that the conspiracy is ongoing.
And what exactly is the evidence you would be introducing on this VGCSA?
The video of it.
And what all does, I mean, maybe I need
The
to,
video
what does it show?
shows Mr. Adams going up to Mr. Williams while on a break. He's appearing to dap him up, if you will. Mr. Williams puts his hand up under the table. One of our lieutenants goes over to Mr. Williams and sort of says, "Give it here." Mr. Williams brings his hand out from under the table, relinquishes the Percocet to him. And later, Mr. Adams is searched. And I think more Percocet pills, more drugs are found on Mr. Adams. And the drugs, the photos and
Okay,
tests of those drugs.
all right. And what's next?
The marijuana was also, so in Mr. Stillwell's cell, there was, on March the 29th of 2023, there were drugs found in Mr. Stillwell's cell that consisted of ecstasy pills, I think contraband, was it cell phone? A contraband cell phone, for him to have gotten those
Okay.
drugs into the jail while he's on trial for
Okay,
kind of actions involving narcotics and the enterprise and the sale and distribution of drugs through that enterprise. We believe is evidence of the ongoing conspiracy.
okay.
Another,
And then the last one, I guess, was the marijuana found on Mr. Ryan. Give me a little bit more background about what your evidence is going to show on that one.
that Mr. Ryan, while sitting in court, I believe deputies may have smelled the marijuana
Okay,
on Mr. Ryan. And when they went back to try and search or to figure out where the smell was coming from, a large commotion was made. And the
by,
deputy,
a large commotion by,
Mr. Ryan, and the deputies found the marijuana attached to, I think, his inner garments.
okay.
We have the video.
Okay,
Okay.
we don't know how it got there. I mean, on the Percocet, you've got an alleged gang member providing it, right?
Yes,
So how about, we don't have anything like that with regard to the marijuana?
we don't have
We
who
just-
provided him with the marijuana, no.
Okay, all right.
I don't know how pertinent it is that we have one that's not on here that is also involving drugs that are brought into the courtroom and provided to another YSL member, but that particular one has been severed, so we don't have that one
Right.
on here.
Okay.
Right.
I think that the first three that we talked about are, I can see how those would be intrinsic to showing the allegations that, this is a continuing, ongoing RICO enterprise. Mr. Ryan being in possession of marijuana when we don't know where it came from, that one, I just don't see that falling within. I mean, it shows, what it shows, that he's in possession of an illegal substance, but it doesn't I don't think it's intrinsic, so I'm gonna rule that one out.
Yes, Your Honor.
The other three,
Your Honor,
yes. Go ahead.
I appreciate the directed verdict that you just gave for one of Mr. Ryan's.
Oh, is that
intrinsics.
one of his, that's not something.
No,
that-
no, I'm saying,
Yeah.
I'm saying you're
That's
keeping
not
it out
anything.
without hearing, but from us, but, regarding Mr. Stillwell's,
Mhm.
okay. We have an indictment with 100, I believe it's 191, could be off, 191 over X.
Yep.
Okay, we also now have a list. At first we thought maybe they had abandoned these 53 and they were narrowing it down to 4, but no. It's 53 plus 4,
Yeah.
57 plus 191. That's 248, I believe. 248 uncharged events, or not substantively charged
Right.
events in that are coming into this trial. Regarding, the state keeps saying, and this shows the enterprise. Okay, there were apparently, I've seen photos, I wasn't there. There were pills that were recovered from Mr. Stillwell's cell, where he has a cellmate.
Okay.
Okay. There is absolutely nothing about those pills that suggest they were provided by anyone associated with YSL. There's absolutely nothing that suggests that those pills were going to anyone associated with YSL. There's absolutely nothing to suggest that any proceeds from those pills were being provided to anyone in YSL. There was a phone. I have not received any information from that phone that suggests any link at all to YSL. I am not saying my client's a drug dealer, but what I am saying is people that are in possession of drugs, whether it be my client or his cellmate or someone else, are able to sell drugs without being part of a huge enterprise and without any evidence that somehow this is linked to YSL. This isn't intrinsic. The test for intrinsic is an uncharged offense arising out of the same transaction as the charged offenses. I don't believe that's the case. Evidence necessary to complete a story of the crime. That is definitely not the case in this scenario. And it's inextricably intertwined with the evidence for the charged offense. I don't believe that's the case either. So
Well,
I don't know why this
I
is.
understand. Thank
And
you for.
and just so you know, Your Honor, he is charged on a separate indictment. I believe it's indicted. If not, it's in a CP case still, but he is charged separately, and that case is pending in Fulton County Superior Court.
Okay, appreciate it. Thank you for bringing my attention to that.
Your Honor,
Yeah.
if I may a bit further, the one case,
On which?
really regarding all three of them. I'll
Okay.
start specifically with the stabbing as the state did.
Can I rule on this other one first? Give me just a second.
Which other one?
The one that Mr. Sharp
Oh,
was
yes,
just
yes,
talking
Your Honor.
about. Okay. So the Stillwell had a cellmate. Is there any evidence as to where the drugs came from, or that it was his, or that the cell phone was his, or connected in any way to YSL?
Well, two things. So yes, we believe that, I think we have, do it body cam research. We believe that the testimony from the deputies within the jail would establish his ownership of it, but more importantly, what we have, I briefly touched on it, was the other YSL member whose intrinsic act that we've not put in here. The pills, if we call them purple hearts, blue stars, and yellow diamonds, they were trafficking amounts in Mr. Stillwell's possession, and they were trafficking amounts in the other YSL members' possession. That is not on here and that has been severed. They are the same type of pills, and they are a large trafficking amount.
Okay, but
and we know that at least that other one, that other YSL member smuggled the drugs into the jail, or at least into that area, through the courtroom. as it was described, it was enough in one, it was a pharmaceutical.
Okay, so any evidence that what was in Mr. Stillwell's cell came from that?
Other than it was that they were just alike. If you looked at photographs of it's not like you had all white pills. Like you had the same array,
Blue,
variety,
purple, and
to use just some colors. Like there were literally at least three different colors and three different shapes of pills. And they were the same, three different colors and three different shapes.
and you can establish that those were YSL related?
Yes, because
How?
when you say those, you're talking about the ones
So
that
if
originally came in?
I'm to accept that y'all have enough that you can make the assertion that the pills that came through some court proceeding to this other person who's not a part of this trial,
Right.
are the same that are in Mr. Stillwell's cell, then what's the YSL connection?
Not the
there?
same pills or same,
Type, the
Yes.
same, shipment or whatever, the same
that person,
loop.
that person was in this trial. That person was in this trial during that time.
Okay, but them being in the trial and co-defendants doesn't establish what the assertions are.
No, it's the, not similarities, the exactness of like,
No, I'm not asking at this point, like, assuming for the sake of argument that, yeah, these pills all came from the same place. And he, in fact, then what's the YSL tie-in?
may we approach with a member of the.
Sure.
Receiver, so we can hear what's going on.
I didn't know y'all didn't have them. They're not up here. Yes, you may.
Thank you.
So are y'all satisfied about, our other bench conference was about the location of that other person, everybody? I just assumed that y'all All right, I am, with regard to the contraband in Mr. Stillwell's cell, I'm gonna rule that out as well. And I mean, you may have another indictment against him at some point in time, and it would all be appropriate to come in there, but not for this case. So that, now, Ms. Abbasi, what do you want to say with regard to the other two?
Yes, Your Honor. Your Honor, actually, the state cited when they discussed the stabbing, the same case I cited, Brown, which had, as Mr. Shard said, those three circumstances. Uncharged offense, which arose from the same transaction or series of transactions as the charged offense. That's actually the topic of discussion in Brown. And in Brown, it was a robbery.
We're going to take just a quick little break, just a quick little break. Okay. I took a little break there, got some water, and one of my guests is catching up a little bit. So I wanted to give some time there. I looked up the Bruton rule. Oh, y'all, I'm out of breath. Running down the stairs. I mean, back up the stairs. I looked up the Bruton rule, and it specifically talks about a defendant that cannot testify, and I think that's the defense argument. They can't cross this witness that has that plea in that is talking about YSL. Whew, yeah, forgive me. That is figuring YSL as kind of like the gang, or they are part of it and that sort of a thing, that it directly implicates their client. So it'll be interesting to see how that piece plays out. So I like this new attorney that has kind of joined the room. She's on her argument. So they got the pharmaceutical piece and the pharmaceutical meds and the marijuana that was in the cell, because that defendant also has a cellmate, and the judge wanted evidence showing that they can show how he got, regardless of the size, regardless of the colors, and how everything lines up. I need you to give me evidence that shows how he got them. And they couldn't do that. So she ruled that out. That was a good win. Now, this attorney is giving us an argument on defense of the stabbing in the jail. So I like her. She's come to the room. She is looks like the co-counsel or maybe even the lead counsel for the defendant who has the piece out there about the Miranda rights and the Miranda rights not being read. So I found that interesting. Okay, just a quick little break here. We're going to get back to the argument. Amy, check in with the chat and let me know how you're doing, if you're caught up. All right, here we go.
Robbery, which happened 1 hour before the charged crime. If the state is going with it's part of the same transaction or series of transactions, then we have a very serious problem with proximity, because the case law is not anything a conspiracy does that happens over the lifetime of the conspiracy qualifies as intrinsic. It has to be closely linked with the others, closely linked with the other charged offenses within the indictment. Your Honor can look at Sanchez Villa versus State, just 341 Georgia App 264 from 2017. Within that case, the evidence the state was trying to present, the court found all of the cases the state submitted distinguishable. And the same is true here when Your Honor goes through the cases. Okay. As far as being part of the same transaction or series of transaction as the charged offenses. This, like those cases, is attenuated in time. For ones which do have more time in between, they discuss how in those cases, the defendants in their other uncharged acts were in the exact same role. So in one, it was trafficking cocaine as the lookout. In the uncharged, trafficking cocaine as the lookout. There were very specifics linking them.
Were any of these in the Sanchez Villa, either those facts or the cases that are distinguished, either a RICO charge that was involved or a gang enterprise?
I will double check because they go through quite a few cases. I'm going to have to look back through all of them. I think the hallmark of it that we get within Sanchez after they discuss all these cases, the evidence in this case, the Sanchez case, is considerably more attenuated in time and space from the events leading up to the charge offense. So it offers little to help the state. They continue on and say that, well, as far as this goes, we're not in a circumstance of completing the story of the crime. This is just expanding it.
Yeah,
completely.
I mean, right, it's a different crime, but it might have been a different thing if they were charged with a RICO count in Sanchez. So that to me is what, if these were just whatever the other charges in the indictment are, then I would say, no, but it's the kind of enterprise nature and the ongoing nature that.
And I certainly understand that, Your Honor. I think, however, to say, well, it's part of the conspiracy basically opens the door to anything any defendant allegedly who is a member of YSL does, then automatically becomes part of the conspiracy and automatically comes in simply because it is intrinsic. I think with a lot of this, Your Honor, we're getting close to some due process concerns here. The defendants are on trial for the offenses they were indicted of. That's what they're on trial for. They're not in trial for the enterprise continuing in 2023, that it was still ongoing. That's just not relevant. If the day after indictment, every one of the defendants got together and said, whatever our group is over, and it was completely disbanded and no longer continued to exist. That wouldn't be relevant either. What they're indicted for is what they're on trial for. So here we're expanding. That's, I think, a lot of what's happening with our social media and other things that I guess the state has found afterwards. They're now being tried for things the grand jury never heard about. And that specifically is a violation of due process. I can supply to Your Honor the U.S. Supreme Court case law.
No, I'm with you on that one. And I am very skeptical of the state's argument that any uncharged, not showing up in the indictment overt act that they offer could in any way support, if found, a RICO count being established. So unless I hear otherwise, which I don't want to hear otherwise right now, we'll take that up another day, but that's not our issue right now. But yeah, I think the state's got some convincing on that count. But with regard to whether, it's intrinsic, I want to get it right. I want to follow what the law says about it. So I think that the key issue here is if we're talking about RICO or we're talking about, a gang enterprise kind of thing. So maybe we could all do a little bit more research on that.
I did look at, in the state's original notice, they cited a proposition, I believe that was cases have been in gang and conspiracy prosecutions, gang and conspiratorial activities have been classified as intrinsic evidence. They then cited a number of other cases.
Mhm.
There is not one single case I can find in any case at all where the intrinsic actions come after the indictment, because that's the touchstone of it being intrinsic, that it really is all one thing, that the story doesn't make sense without all of these pieces. And these things hadn't even happened yet. So
Yeah.
it's not possible
Let-
that they could be essential.
Let me ask you this. If, for instance, and this is entirely a hypothetical,
Yes.
but if this group got together and stabbed this, whatever his name is, Bussy, not because he messed with Mr. Ryan's commissary account, but because he was going to be a key witness in this case. And I'm sure the state, if in this hypothetical, would argue we're trying to send a message that he better not be a key witness in this case. Would the argument be different then?
Well, yes, they wouldn't be trying to admit it as an intrinsic act. It could be a crime in and of itself separately.
No, we're not talking about then they get separately indicted. We're talking
Right.
about they're in the middle of this trial. This happens. It's not obviously set forth in the indictment because it
Right.
just happened.
It would be 404B and probably fall into a category there, which would make it admissible for a basis which was not character. It just wouldn't come in as under intrinsic.
Okay, so you would still make the same argument that it couldn't be intrinsic evidence, even for that, because it occurred afterwards.
Based on the definition I've seen of intrinsic, I don't think it's possible for something which comes after to be
Okay.
necessary to complete the story, unless the story wasn't complete at the time of indictment. That's fundamentally unfair to try them for something which hasn't happened yet.
Okay, they're not being tried for it.
Correct.
But okay.
Based on your
All right,
example.
well, y'all try to find me some more on point law on both sides, please, if you could. So maybe that'll be my preliminary ruling, subject to revisiting, okay?
And Judge, there was one other thing. I don't know that it'll have any bearing on the court's ruling, but in that instance where where the drugs were found in Mr. Stillwell's cell, there were, Miss Hilton pulled up the photograph that I asked her to, and there was a shank.
Is the shank inscribed YSL? Then
No,
it doesn't,
no.
I mean, it makes Mr. Stillwell look bad, but it's not intrinsic.
Yes.
Okay.
Your Honor,
Yes.
if I may,
Yes.
before you make a decision on the one alleged intrinsic act that was referenced by the state involving the supposed passing of a Percocet pill from Mr. Khalif Adams to Mr. Williams, I would ask that the court at least go and take a look at the video that was referenced by the state. I think it's instructive. I also think that well, fortunately for us, paints a different picture than was recited by Madam Prosecutor. I think the events did not occur in the manner that she referenced. I was present. I was sitting right next to Mr. Williams. I think the video will show something being passed to Mr. Williams, not him hiding his hand underneath the table or bringing it out and then giving it to the deputy, or the deputy saying, give it here. It didn't happen that way. And I think that goes into the analysis of exactly what happened.
All right, why don't you just tell me what you recall or what you think the video shows?
Sure. What I recall, and what I know happened, because I was
Okay.
sitting right next to Mr. Williams in the front of the courtroom, is that there was a break. Mr. Adams, who was sitting in the rear part of the courtroom, came up, and as he was going towards that door, goes as though he's going to give Mr. Williams a high five or a dap or something
Right.
like that and put something in his hand. There's a deputy who's standing about 2 feet in front of Mr. Williams. Mr. Williams looks surprised. Mr. Williams has it in his hand and puts it down on the table immediately. There is no putting hand under the table to try and conceal it. The deputy who I was within earshot of did not say, give it here. Mr. Williams looks at it and puts it down on the table, and that's it.
Okay.
At which point another deputy sees Mr. Adams and either takes him, I don't remember if they took him in the back or brought him back here.
Okay.
He was searched in the back, as I understand it. I think court recessed after that because of those occurrences, but that's how the incident actually occurred.
Okay. Can y'all send me that video?
Yes, and
Okay.
the deputy, the lieutenant would also be a witness
Okay.
to what I'm saying.
All right. Well, I mean,
The version
I would
I'm
imagine the video shows what happened. So.
It does.
It does indeed speak for
All right.
itself.
Well, we'll come back to those two. All right. So that takes care of the allegedly intrinsic, but according to the defense, can't be intrinsic because they happen later in time than the indictment acts. What about the other intrinsic or allegedly intrinsic acts that there has not been a 403 analysis on yet?
Can I just add something to the last? Your Honor, can you ask what the prosecutorial need for this is?
I can, but with intrinsic acts, that's not part of the analysis.
Yes, 403 is the
Well,
analysis.
403,
Which
So-
includes the prosecutorial need, waste of time, prejudice, substantial prejudice outweighs any probative value. But to me, this is a big case. It's
It
been going on a long
is.
time, and now intrinsic acts. So yes,
Okay.
I don't know how much the state needs to prove that Mr. Williams was knowingly or unknowingly given an alleged item. I'm not so sure the crime lab came back, but I can't answer for that.
has the crime lab come back?
That may be true. I don't know. I don't remember.
Okay. All right. So we now have a 403 argument or objection.
So, Your Honor, I think that the court had it right regarding the need to analyze, looking at the prosecutorial need. If it's a 404B act, then that would be a situation where we would be looking at the prosecutorial need, but it's not. We're alleging that it's an intrinsic act, and looking at 403, Your Honor, the analysis is it substantially more prejudicial than probative? And it's simply not, is our position. He's alleged to have, Mr. Williams and the other indictees here are alleged to have conducted drug transactions. One of the acts on the indictment involves
Them having a trafficking amount of drugs, right?
at least one. So we would argue that it in no way can be viewed as substantially more prejudicial than probative, and it's intrinsic. But we're pulling up the video too.
Well, I mean, I guess is that intrinsic is yet to be determined based on the time period, but
Your Honor, this is
Yes.
not really my argument, but I have got to weigh in here
Oh,
on
please
this
do.
issue. Yeah, thank you. I'll get my 5 minutes in. The 403 analysis is not limited, as you know, to is it more prejudicial than probative? As Mr. Steele said, you also have undue delay and waste of time. And those are factors as well that I'm not surprised that the state ignores, because they seem to have no concern for delay or waste of time. So those are factors that the court should consider as well, Your Honor.
all right. Thank you. Okay, well, I will give y'all a couple of days to, if you can find more on point law, provide that. And if not, I'll just have to go on what we've got and make a decision. I'll take a look at the case that got cited and the cases within that. And then if need be, do the 403 analysis. I may not get to that, but okay. So that's those. What about the other intrinsic acts that 403 hasn't been done on yet? Do y'all just, is there a list? And is it? And I can't, let me see, I'm not sure quite who filed that one. Or maybe Mr. Sharp just told me there are some that the 403 hasn't been done on yet. From the November 6, 2023 filing, but I don't know which of those.
And some of them have already been, so Judge Glanville made an initial ruling
Right.
on one day on 1 through 3. And then throughout the trial, we dealt with and admitted evidence on number 4. Does the court have
Not
the
right in
list?
I'm
front
not
of
sure
me.
what list you're referring to.
The filing on November the 6th, 2023.
Yeah, I think
Of
I've
the-
got that. Give me a second to locate it. Okay, yep, I've got it.
So, Your Honor, my recollection is that we began discussions on this one day a long time ago.
Okay.
And I agree with the state that they have presented evidence on some of these incidents, some of these acts. Your Honor is saying that we haven't done a 403 analysis. I don't believe we've
Only
done.
because y'all, that's what I thought you had said to me.
Okay, if I said that, I believe I misspoke. I don't believe
Okay.
we've done really any analysis on this list. Meaning,
Okay.
I don't believe, speaking for the people on this side of the room, I don't believe that we are conceding that they're intrinsic.
All
in
right, so
getting
we
into
may
the
need
403.
to, starting with number 5, look at all of them.
Well, Your Honor, I thought we were going by the state's July 31st witness list. So that would not encompass all of these things on here. That witness list went through by what offenses it was set to
Oh,
prove or
this one?
acts. Yes. So I was relying on the witness list when filing motions in limine of what they actually intend to prove. I thought that was the whole purpose of.
Well,
Judge, I'm not sure if Ms. Abbasi, we filed this November
Yeah.
the 6th of 2023, and I know she wasn't here at that time, but we, this is the argument I think that Mr. Sharp made. This is the one that he sent out with his objections. This is the filing. So this is the one that we're addressing.
okay, well, I mean, if for instance, you're not gonna, you don't intend to use, 20 through 30 anymore, tell us that. If you still think you intend to use every one of them, tell us that.
A lot of them have already been completed, and there have
Okay.
been testimony, there's already been
All right.
testimony on a lot of them.
Okay, so can you tell me right now?
Yes.
Which that's true for?
Number 4, the 5/12/2013 aggravated assault and home.
Yeah, I mean, I've got it right in front of me, so if you just want to say number 4, that's fine.
Number 4, number 5.
And you said a ruling had already been made on 1, 2, and 3?
Yes,
Okay.
we didn't admit them, but they were. Okay, so we did not admit evidence of 1, 2, and 3. All that we did was address them initially. We didn't admit evidence, and we don't intend to, but those are the only 3 that were addressed initially.
And you don't intend to, so you're not intending to introduce those 3?
Right.
Okay, well then we'll cross 1 through 3 off the list. Okay, 4 has already been admitted, 5 you said has already been admitted.
Right.
Now what?
Also, as it relates to 7 is one of the overt acts listed. The reason that we included it here is that Shannon Stillwell's name was not in the indictment itself
Okay.
on that overt act. The same as to number 8. What? I said the same as to number 8.
Okay, so those are listed, those acts are listed as overt acts, but Mr. Stillwell is not listed in the indictment when
Right.
you're talking about the overt acts. Okay,
Correct.
all right.
Um,
What about 6?
6, actually, we so 6 is gonna be talked about. It has already been talked about
I thought so.
some, and it'll be talked about some more.
Yeah, I thought it had already been talked about some. So I mean, that's in the past, basically. 7 and 8, given that they're overt acts, adding Mr. Stillwell to them, that can still come in as intrinsic. What else?
10 has already
How about
been,
9?
9 has not been talked about.
And do you intend to still present evidence of that? I mean, you do at some point need to streamline your case.
So we can strike off number 9.
All right.
I believe. Ten and 11 have already been alluded to, and in fact, 11 has been discussed by the witness who's currently on
Okay,
the
so
stand.
those are already in.
Yes, and I think that the court at first asked me to tell the court which ones that we had
Well, you
already-
know what? Why don't we just walk through them the way we're doing now? Because you might decide on some other ones that you don't need those.
All right. So Hill Street there will be testimony given on that through Detective Dennis.
Okay. And
Oh,
his.
he already
involved in
talked about
that.
it. Ms. Hilton has
Okay,
reminded
so
me.
that's already in also. Okay.
Number 13, a witness has already talked about,
Okay.
Mr. Copeland on the stand. Number 14 has already been testified about.
Okay.
We've taken off number 15.
Okay.
Number 16 has already been testified about. Number 17 has, we've already presented evidence on.
Okay.
Number 18, we've already presented evidence on. Number 19, we intend to present evidence on.
All right. And tell me, is that like part of the gang rivalry leading up to Mr. Thomas's? I mean, I'm just looking at the date for that, or why is that intrinsic? Why is that a part of the whole story?
Already.
We've talked about it, or y'all have talked about it.
She's right. We did.
I'm not aware in
The aggravated assault at Trestle Tree on the 8th.
what case is that?
The aggravated assault at Confederate Court,
I'm aware of that, but
through Detective Dennis. I believe that when he gave, I'll have to go back and make sure, looking at our, at the flip chart that we made while he was on the stand.
Okay. But would this be part of the back and forth that y'all assert led up to?
It was part of the, yes, part of the shootings that they went back after the murder of Donovan Thomas and found out about. So that when we say back and forth that led up to it, they
Uh-huh.
started investigating those shootings after the murder of Donovan Thomas. And
Okay.
this was one of the ones that
And this is a shooting of whom by whom?
at Trestle Tree, which would have been if gang territory, we allege by YSL members. but
Okay, and what evidence do you have of that?
We did. Okay. So, and just so that Mr. Sharp has that, it's for 150080094. We've already put the CAD report and the 911 call in.
okay.
Okay, well, that pretty much
Well-
sounds like that's in then.
Well, I don't
Okay.
agree. I mean, what's I think obvious right now is I've been very involved in this case.
Mhm.
I don't know what this January 8th shooting is. I'm asking Miss Love. She doesn't know. So I'm trying to figure out how anyone could argue, if no one even knows what it is, how it's so intrinsic to this case.
Yeah, I don't know if she doesn't know what it is.
Well, I mean, I
period,
keep
or if
asking,
she
I'm
just
giving
doesn't
a-
know right now what it was. So who is alleged to have done this? So, or is this just a general, we, the gang experts, found out about this and we think this was a part of it? It's so, okay. Is there gonna be more besides what's already been
No,
testified to?
No.
Okay, so it's already in. Okay.
Okay.
number, what number?
20.
20. We have already heard testimony on this one.
And that's all we're gonna hear as to that?
Yes.
Okay.
Yes. And we've already heard testimony on 21
All right.
and 22.
Mhm.
We're not introducing 23.
Okay.
24, we've already heard testimony about, and we will hear more. This is actually where we got that video from that we mentioned. Mr. Sledge, that's in the folder for Mr. Sledge.
Mhm.
Number,
So, hang on. What else is gonna come? I mean, great if the video happened to be from there, but what else is gonna come in about this ag assault criminal damage?
well, Antrevia Smith is one of the witnesses that we've listed,
Mhm.
and her testimony.
That's a victim?
Yes, that's whose
Okay.
house it was.
All right. Okay. Go ahead then. 25.
This is January the 28th. I thought we'd already introduced that. Kendrick's possession of firearm on January 28th. $15.02. Back to 25, 20.
Okay. That's fine.
26, we're not going to introduce evidence of. 27, we've already introduced
Okay.
evidence of. 28, we've already introduced evidence of. With the exception. So 28, Ms. Hilton is reminding me that with the exception of Shannon Stillwell's involvement in the Little Wayne bus shooting, it has come in, but it was added here because Shannon Stillwell's name was not on the paper.
All right, that's fine.
29 is coming up. The shooting at Club Crucial preceded the shooting at Adele Drive and Drew Drive, and that's duplicative of 7 and 8. So 30 through 33 are the same.
So, I'm sorry, 30 through 33.
I was saying 7 and 8 if the court would just.
Oh, okay. So they're just listed on here twice, basically. Okay.
34 is already.
So I can just cross off 30 through 33, right? Because we've already covered them. Okay. Okay.
36, we don't, well, actually. I asked the court to allow us to come back to 36. I believe that there are ruling may have been made on that.
Okay.
At first,
All right.
I want to check. 37's already been testified about, 38's already been testified about. 39, we don't intend to introduce evidence of.
Okay.
40, we do intend to introduce evidence of.
Okay. That seems pretty intrinsic.
We were taking out 41, Mr. Linder has been set. Wait a minute. Oh, Judge, I
Yeah.
apologize. As far as 39 comes in, I was thinking of another incident. 39 is coming in. That is what led to the arrest by of Mr. Kendrick and Mr. Arnold with the firearms that Mr. Kendrick entered a guilty plea to that involved his plea colloquy that we spoke about earlier. But the fact that Mr. Arnold didn't want to identify Mr. Curtis or testify against him at trial is not, we're not putting that part in.
Okay, but that Arnold was assaulted by
By Mark
that you
Davis.
want to have come in. Is that what you're
Yes,
saying?
yes, yes. That is what led up to the arrest of Mr. Kendrick and Mr. Arnold. They went to retaliate. So my apologies. That's 39 and 40 coming in. 41 being taken out. 42, we don't intend to introduce evidence of 42.
Okay.
43, we do intend. 43 is coming in. Well, we intend to introduce evidence of 43. That's tied to the armed robbery that he's alleged in the indictment to have committed
Okay.
on October the 11th. 44 comes in because that, we believe, is the motive for the murder. That is the last murder on our indictment.
Okay.
45 similarly is tied to the Shamel Drinks murder. So we would argue and would ask that that be allowed to come in. 46 as well is tied to the murder of Shamel Drinks. As a matter of fact, 47 and 48 and 49 are all tied to that murder. So the ones that we've listed as intrinsic that the court has heard us talk about, for the most part, 90% of them, I think, are part and parcel of acts that have been alleged in the indictment that just didn't include certain aspects that are now listed on this supplement.
All right. Yeah, I mean, there's not a whole lot. Well, what about 50 and 51? Those are the ones that we just talked about. Okay. All right. So other than those two, I mean, honestly, most of it already has come in, or is like, I don't think even arguably not intrinsic to the rest of the crimes and overt acts. So I think the rest of these, not 50 and 51, but the rest of them, unless you've got some kind of a 403 argument to make, those seem appropriately in. Okay, so sounds like that settles that, other than those two subsequent acts. All right, with regard to I think I already asked y'all to do this, but the Bruton portions of Mr. Kendrick's statement, y'all are gonna try to get together on that, or have y'all already done that?
I thought it was agreed that because I listed out what I believe are redacted portions, and I gave the timestamp on the actual interrogation, then the state can say, we disagree or we agree, we could get together.
Okay, but that hadn't been done yet. Y'all still need to do that?
Right.
Okay, well, that's something I think we might get to tomorrow.
As well as we were just served by Mr. Williams a bucket of exhibits. I think he wants to introduce with somebody at some time
Okay,
through a Dropbox link. So we could probably discuss those this week as well.
okay.
You can, but it'll take about 8 seconds. There's not much to discuss. I added a video and I specifically wrote what it is, and then I added it to the Dropbox so everybody has the world that Mr. Williams may introduce at trial.
Okay.
Exhibits. So it's just one video.
All right. So do you believe the state will be able to examine whatever portions of Mr. Kendrick's statements they think need to be redacted, and let us know?
Yes, I looked
Okay.
at some of the, I don't agree with them, but I can look at them and have some agreements if they're already by tomorrow.
Okay, sounds good. So tomorrow we'll still need to do that. We'll need to do the PowerPoint.
We served that one.
Right. So I'd like to maybe take that up tomorrow or sometime this week. I want us to be ready on as much as possible though, so that if we finish one topic, we can move on to the next one. And then we've still got I guess after those two, we just keep moving through the evidence that are in the first 60 witnesses and, figure out any kind of rulings that can be made ahead of time as to those. And that would include Mr. Sprinkles. Okay. And have y'all done the next 30 yet?
They have everything until 60, but we will work on 61
Through 90?
through 90.
Okay.
Your Honor, just
Mhm.
calling this to your attention. Ms. Hilton is correct. She identified specific co-conspirator statements or things that they allege are co-conspirator
Right.
statements. In reality, we have a lot of different voices here.
Mhm.
I have reviewed all of the wiretap calls
Yeah.
that are relevant, at least.
Okay.
But in my opinion, there's going to be no way to litigate those matters other than just going through them. I hate to say that, but we're not going to agree that any of them are in furtherance of a conspiracy, and we're not going to agree that a number of them, we don't even know who Mr. Garlington is talking to.
Okay.
So that is something that I would humbly suggest should be on the agenda, because we're going to have to work through that.
Okay. I mean, yeah, I agree. This is the wiretap. We got to get through all of it. So what witness is that going to come in through?
Your Honor, that's going to come a little later in trial through Investigator Viverito. So this will be probably towards the end when we're talking about the Shamel Drinks murder.
Viverito?
Yes, Your Honor.
Okay, well, if we get through, I mean, it's a big chunk of stuff we have to do outside of the presence of the jury. So it may not be what is first on tap, but we're going to try to utilize our time. So that's something we need to turn to as well.
And to give just a court of reference, it would be after witness 91. And this is when Investigator Viverito comes up, probably her third or fourth time. So,
Have y'all given thought to streamlining your witness list and your evidence?
So Judge, just so that the court is clear, early on, I don't know how familiar the court is with the number of witnesses that we initially started out with, but we started out with over 700. And before, I believe Mr. Weinstein filed his first motion to limit the state's case with the former trial judge, the state announced to defense that not only would we actually be asking for an earlier start time and a later finish time, but we actually told them that we had reduced our list from the over 700 to just over 200. And we've reduced it further. And then after that was when I believe Mr. Kendrick filed a motion to force the state to reduce its list, but we had already said and done that. So now we've reduced it even further. And I believe that we are at that point where we've reduced it. The delay that Mr. Kendrick referenced in his motion has not been attributable to the state. We have had a number of administrative days. We have had a number of delays that were caused for other reasons that had nothing to do with anything that the state's case entailed. So our case and the length of our witnesses is not prolonging this trial at all. And our position is that we have streamlined it considerably. We continue to streamline it even after our first streamlining that we apprised them of.
All right. Well, all I'm saying is, please try to do what you just said you are doing, which is continue to streamline, and I don't have the entirety of who's saying what to what, but you do have the thing that says what counts each witness is going to go to. Just make sure that you're not being cumulative and that the witnesses you're calling are basically worth calling, that they're going to add something material to the jury's ability to decide this case.
And Your Honor, we have indeed been doing that. I think that the main cumulative objection has come from, as I remember, they've argued, well, they've called a gang expert, 3 gang experts, and that's cumulative. But each gang expert has talked about a different set of information that they have knowledge of. And they also had factual information that they were both fact witnesses and expert witnesses.
But you're expecting 2 more gang experts?
In terms of new ones? There were 2 left on the list that we haven't yet gotten to.
Right. So
one of them we may not call.
Okay, well, you would need to be able to express what it is that expert or those 2 experts is going to offer that hasn't already been covered by the three that have already testified?
We would.
Okay.
And Your Honor, I would
Yes.
like the opportunity at some point this week, I expect the state to answer, to respond to the motion that we filed, but I would like the opportunity to actually argue that in front of you.
Well, I mean, I don't know that I need a response from the state. I also don't need argument from you. I mean, I understand what you're asserting
I mean,
in your
just-
motion.
I mean, just today, Your Honor, they say that gang experts, for example, because that is one that we have gone to, that they have not been repetitive. But just today, and I wrote this down because it's just emblematic. Just today, Ms. Love said, quote, our gang experts have testified to B replacing C. So there's a situation there where their gang experts have testified to the same thing multiple times. There's B replacing
Yeah.
C. It's constant, Your Honor. And there's absolutely no reason that they should get to run this courtroom. Now, I'm not asking to run it. I'm asking you to run it.
I'm running it.
Okay? And you have the ability to put a time clock on the state. We're way past the time. I'm just going to finish real quick. We're way past the amount of time that we have told the jurors that they will be here. And that is a factor that you can consider. We told the jurors, now I remember 6 months. Other people have said we told the jurors 6 to 9 months. We're going to far exceed that. There's any number of reasons, and they're outlined in the motion. If you don't want me to argue it, I won't argue it, that we can put a limit on the state, or you can put a limit on the state.
Okay, I understand what is set forth in your motion. I understand the law. I understand what my powers are as the judge presiding over this case. I understand that cumulative evidence is unnecessary and maybe undue delay and a waste of time. I also understand that the state has a right to present its case and that they don't have to be limited to just one witness per, count in the indictment. They have rights to. So I appreciate what you put forth there. I agree with it. I mean, it is granted. Okay. I will not permit there to be excessive, repetitive witness after witness saying the same thing, exhibit after exhibit showing the same thing.
Well, the relief I requested was to put a specific time, whether it be days or hours or however you want to do
Okay.
it. So if that's granted, I am thrilled.
Well, I'm not sure that I know at this stage, given that we have only not yet gotten through one incredibly long and somewhat painful witness testimony, what that time limit might be. I don't anticipate most of the other witnesses to be as long on the stand as this particular witness has been. And maybe I can get, maybe let's just ask the state right now, like time-wise, do y'all expect any of your other witnesses to take as long as Mr. Copeland has thus far taken?
No, we didn't expect
Okay.
him to take them.
But Your Honor, this is not the only witness that has
I
taken this
cannot do
long.
anything about what happened before I was the judge.
I appreciate
I
that.
just
And
can't.
I'm not asking you to. All I'm saying is that the state's saying that they don't expect other witnesses to take this long. There have been repeated witnesses that have taken weeks.
Okay, well,
And I mean,
let me drill down a little bit more, okay? So are there any other witnesses that are gonna have video interviews that are anywhere as near as this witness?
No, and
Okay.
for any witnesses that have taken more than a few days, there have been breaks, there have been pauses that have caused us to have to take that witness over a period of time longer than we ever anticipated.
And I hope we don't continue to have sound issues, but nobody can do anything about that, although I'm trying to at least get us a reasonable backup, which should have already been in place anyway. But all right, so I'm going to need an answer as to why there needs to be any other gang expert at all in some amount of detail. And y'all have the witness list, just like, you have the state's witness list. So if there's somebody else like the two extra gang experts that you all looking at the list and knowing the case backwards and forwards think the person who's going to say this, somebody else already testified to all of these same things, then you'll bring it to my attention and we can go through and get answers as to whether those people or those witnesses or those exhibits are cumulative. But I can't know at this point in time. I haven't been in this case long enough yet to see what's reasonable for, a witness to take.
Okay.
Okay.
So I'll be back in a few weeks asking again, Your Honor.
Okay. All right. So I think there aren't any other short things. I'm happy to stay here another hour if y'all would like to. Nobody else wants to. This wasn't even a full day, y'all.
Can I inquire?
Yes.
The item that's I think the computer with the headphones on it, is that going to be in front of the jury? So that
No, that's a ridiculous place for it to be right now. If we end up having to use it at all, and I appreciate the state, bringing it as a potential fail-safe. I think we're going to try while you're doing your oral argument tomorrow morning, somebody is going to come in here and see whether they can even have this be the backup. But it would, as I understand it, we wouldn't be using the video. We would just be using it for its audio output.
So it would.
And it would be up against the
Up
wall.
against the wall,
Yeah.
right. That's where we had it
Like we don't
initially.
even need the video part, right?
Not necessarily, but it would be showing the Zoom. It would just all be the same
Right.
thing that's
But
on every
the
other
jury
screen.
doesn't need to watch that screen. They can watch the screen they already have available. So
Right.
we can slide that entirely up against this back wall
That is where
it's
had it.
out of the way and not, blocking anybody's view.
That's
But-
exactly the way.
But we would potentially use it for sound if our sound system continues to go on the fritz. IT tells me they think they have come up with a solution. I don't know whether they have or not. I also don't know how long it's going to take them to implement said solution. So I have asked them to have something else ready. This may be part of it, but yeah, okay. I'm reading an email that just got sent to me by the head of IT about it. Anyway, we'll try to get all of that addressed. Okay, so we will convene Sergeant Ingram on the scheduling. I had said 12. Is that doable, or is 12:30 just a better? Okay. So let's all plan to convene at 12:30 tomorrow. So when y'all show up at 12:30, it'll actually be the right time. And we'll see you then. Be ready to work on and have objections and responses ready for what we've just talked about. Okay, that's all I wanted to know. All right, so we're adjourned for the day.
All right, that was good. I learned a lot today. That was good, 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 good. Amy, thank you so, so much for joining. We'll be back tomorrow at 1:30, and we can do a little break about 4 or whatever time, and just kind of recap and stuff. So I thank you for joining me, and I'll set up the live tonight, and I'll be back in tomorrow at about 1:30. Talk to you soon. See you then. Thank you. Talk to you tomorrow.